Lordship, may I be permitted to mention, my lord, one restoration application for contempt. Lord.
Restoration application?
Contempt application. I have filed the restoration application. Contempt has been dismissed for default. That's why I am mentioning.
দেখো গ্রুপ 1 এর আমার আছে contempt arising out of which order?
Lordship,
Contempt কার order?
original order was passed in the year 1998, my lord. I have attached the copy of the certificate copy of the order. পুরনো 98 কোন সাহেব ওখানে লেখা আছে অর্ডার
রেজিস্ট্রেশন অ্যাপ্লিকেশনটা কোথায় হবে? রেস্টোরেশনটা কোথায় হবে? রেজিস্ট্রেশন নিতে পারবো? কন্টেম্পটা কি আমার কাছে পাবো? হুম। আচ্ছা ঠিক আছে প্লিজ করুন
grateful, my lord.
And may I have your lordship's kindly to mention that matter is mentioned yesterday, man, and brought the memorandum of appeal, man. After the cause title, man, 2 pages, man.
ওকে
That mat number was subsequently renumbered as SMA, man.
what is the order passed in?
But the read order, man, I've also tagged, man. If your lordship sees, man, the order is also there in the paper. Attached to that memo of appeal.
The order is stated that what was passed in 2nd November 2016?
But that is there, man.
Final ground report.
Yellow tag lagale the order last order. Yellow tag, what order? But against this order, the appeal was preferred.
Notice you have given to the other side?
No, The difficulties, my lord, I am telling your lordship, my lord, that is why, my lord, I am trying to get it, my lord, listed under the heading to be mentioned. But difficulties, my lord, at that point of time, Mr. Bilodol Bhattacharjee was appearing on behalf of Vidhannagar municipality. But he has refused to take the acceptance of the notice, my lord, by saying that he is no more there in the panel, my lord. And the state panel has also changed, my lord. My lord, direction, my lord, if it appears under the heading to be mentioned, my lord, a direction be passed by this court, my lord, then I'll serve, my lord, notice, my lord.
Yeah. 2 mention. File table to be mentioned.
My lord, may I be permitted to be mentioned, my lord? I am praying for inclusion this matter, my lord.
What is the matter?
Irrespective of classification matter, my lord, this is very old matter, 2016, my lord.
Group 1.
My lord, the petitioner is a senior citizen, my lord. He is 80 years old and he is absolute lawful owner of this property, my lord, and the respondent authority have not given porcha in favor of him.
Have not given
Porcha, my lord.
Porcha.
Yes, my lord.
Where is the writ petition?
Petition, my lord, 2016, my lord.
Where is the copy of the writ petition?
Lordship, it is the record is probably in the department, my lord.
So now you want to see that there is a prayer for that. They have not given you porcha. You have moved the honorable court to have the copy of the porcha.
We have made a representation
Or
because they were not issuing the CS porcha in my name. The record was the main copy where the record was found that was torn, so I could not obtain a copy. I made a
bring
representation.
the copy of the writ petition. I'll see that, and then mention.
Deeply obliged.
Actually, may I have liberty to mention this one matter for inclusion, Your Lordship. The petitioner is the owner of this property, but the previous owner they are not moving from the property, and the title suit is going on in the learned court below. In the earlier occasion, Justice Hiranmay Bhattacharya gave an order, interim order for the stay of the proceeding in the learned court below, and the extension order will the, it the extension order.
What is the order? Give the copy. Give the copy. আরে সিও এখানে মুভ করছে কেন?
এখানে WPA group 1
Item number 1.
Yes, sir,
Section 5 application. But in case section 5 application, restoration application, then is only section 5 application.
may I?
That is a combined application is 5. He must file the section 5 application.
May I address the issue? But my learned friend is correct that in the appellate side, when we apply for restoration, it is always, if there is delay beyond the period of 30 days from the date of dismissal, we should accompany or file an application under section 5 of the Limitation Act. But my lord, when we prepared the application for restoration, my lord, we came across few division bench judgments of this honorable court, which says, my lord, that the residuary provision under Article 137 will apply so far as restoration of a writ petition is concerned. Though, my lord, Article 122 of the Limitation Act says that it is 30 days from the date of dismissal, but the reasoning
All this consideration will come after you file an application for condonation of delay.
No, my lord, I have prayed for condonation in the application itself.
So there is a separate application.
Yes, it's a combined. If lordship kindly takes my lord page 16.
I have seen it.
Yes.
Because an application for
Because my
condonation.
lord, if lordship says this is the first prayer, delay in filing the present application be condoned. But if my application is governed by Article 137 of the Limitation Act, then perhaps, my lord, to apply for restoration, the time is 3 years. Then perhaps, my lord, there has been no delay. Because if lordship sees the order of dismissal at page 135, it is dated 23rd of November 2023.
Okay.
And the application was filed within a period of 3 years. So if
Okay.
the residuary article of Article 137 applies, then perhaps in my humble submission there is no delay. Now the issue is whether it is Article 137 that will apply or whether it is Article 122 of the Limitation Act will apply. The judgments of the division bench of this honorable court says
This
Matlab-
copy has been given.
the
You have
main
filed your
petition
opposition
copy
to
has been
restoration.
given.
You have filed your opposition to that.
No. Matlab, I'll be very, it's a very innocuous prayer.
Yes.
I leave it to your lordship. Since this is a very innocuous application, I will not. I completely agree. But since there are division bench judgments, this is the submissions or the arguments that I am advancing. That even I am stuck in this dichotomy whether it is Article 137 which will apply or it is Article 122 will apply, because there are three divisions in the Limitation Act. It's suits, applications, and appeals. If it's the division of suits, then 122 will only apply for suits. Writ petition is not a suit. If writ petition is an application, then the residuary article of 137 will apply. Then my application is within the time specified. Then by abundant caution, still I have prayed for condonation of delay. And if lordship sees, I have given reasons in my humble submission as to why there has been.
File an opposition to this. We'll examine this, what his submission is. If required, then there will direction.
Yes, your lordship will kindly hear me out
Yes,
on
yes.
this issue. If lordship is not satisfied, on the next day I can come and apply with a very small Section 5 application, and lordship will condone
that
the
will be
delay.
correct.
Because I have explained the reasons as to why there has been some delay in.
If there is no delay, there is no question. You file your opposition to. You file your opposition to that. We'll examine what he is submitting. Let him come up with the opposition.
Yes, let
Mr.
this.
Chundicharan De, learned advocate for the state respondents, submits that there is no separate application for condonation of delay. Mr. Orithro Basu, learned advocate for the petitioner, submits that in the event Article 137 of the Limitation Act applies to the facts and circumstances of the case, the application for restoration is well within time. That is within a period of 3 years.
Yes.
3 years. Mr. De at this stage seeks to file opposition to the restoration application. When, Mr. De? Let such opposition be filed within 2 weeks. 2 weeks, make it 2 weeks. They will take some time to.
My lordship gave them 7 days on the last occasion.
7 days. Make it 2 weeks. 1 week reply. Release this matter after 3 weeks. The other applications are also there.
Today, only this matter is appearing, I think. But only one indulgence, since it's a restoration application, may it have some precedence in your
It
lordship.
will come up. Applications will be taken up at the top.
Grateful.
No.
Let the directions for filing of affidavits, let it be peremptory, my lord.
Okay. Mm-hmm. 11. What's the number? 8.
Item number 8.
I'm for the writ petitioner, my lord.
This is the report in terms of your lordship's order.
There is no stay in the appeal. My cross objection is not standing in the way, lordship. May I just make one submission, lordship? I'm the writ petitioner, my lord.
Yes.
May I just make my submission, lordship? Lordship, on 21st of May, your lordship's direction was as follows. The officer in charge, Borough 6, Howrah Municipal Corporation, is directed to file further report of action taken within 2 weeks of reopening. My humble submission, lordship, the corporation has not complied with your lordship's order.
Already taken action, 5 floors have been
Let them
demolished.
let them
Now we are
produce a
saying that the
report.
G+1, that floor is
That
to be
was
demolished,
done
we are going to
much
demolish.
prior to your lordship's passing
That
or the
but
order.
we are going to demolish.
They have given an
They have
undertaking,
given us
lordship, that they will demolish.
order about
Constructive
action
But
taken
they,
every time.
but they have not filed any report to such effect. Your lordship's direction was,
100% is there. We
that
have
is
filed a
not
report.
action, lordship, in my humble
Action
submission.
cannot be taken immediately.
The same thing is being stated before my lord every single day, that there is 100% deviation.
We have done. We
But
have
since 21st of May,
28 days
nothing
we
has
have
been done.
demolished.
Nothing has been done.
Will be not within the permission
And now there is a difficulty, my lord. There is a
construction from second
Problem is
floor
that
fully demolished.
building G+1 is in very situation is very delicate, my lord. But even then also we have to demolish because 100% deviation is there.
So let them take
Then-
steps.
শেষ করতে দিন, নাহলে আপনি বলুন তারপর আমি বলবো।
They have been waiting since May, your lordship.
They are
Kindly
waiting
considers
and they
that.
Let him
Lordship,
submit.
I'm sorry, my lord.
My lord, 4 floors when were demolished for 28 days. G+1 foundation has been also been in a difficult position. We have called our engineer. They are already inspecting the premises so that the demolition can be done, keeping the G+1 building as it is.
Okay. Yes. Okay.
And 100% deviation is there as per your lordship.
These deviations will be removed.
Should have to be removed, but some time
Sure.
will be taken because
A report, a report filed on behalf of the Howrah Municipal Corporation, respondent Howrah Municipal Corporation. Sorry. The report filed by
after this there is no scope for any exception, I think, because 100% deviation.
the officer in charge, Borough 6, Howrah Municipal Corporation. Added respondent.
Added respondent number 9,
Added
my lord.
respondent is taken on record. Mr. Swapon Banerjee, learned advocate for respondent Howrah Municipal Corporation.
সন্দীপন ব্যানার্জি সন্দীপন
কি বললাম?
similar.
Sorry.
My lord is very
Mr.
related to Swapon
Sondipon
Banerjee.
Banerjee, learned advocate appearing for respondent Howrah Municipal Corporation, submits that there is 100% deviation so far as which floor is concerned?
Both floors.
Ground and first.
Ground and first floor.
Yes, lordship.
Ground and the first floor of the building. He also informs the court that the officer in charge, Borough 6, Howrah Municipal Corporation, has caused inspection and shall take necessary action for removal of the deviation. Mr. You are Mr. Swapon Kumar
Now
Pal.
Swapon comes.
Mr. Swapon Kumar Pal, learned advocate appearing for respondent 6 and 7, private respondent number 6 and 7. Private submits that the respondents have preferred an appeal being met 1399 of 2024 against the order of this court dated which order?
21st May 2024,
21st
lordship.
21st of May 2021. And it is appearing in the list.
25th May 2020.
Okay. Officer in charge, Borough 6, Howrah Municipal Corporation, is directed to take steps as submitted by the learned counsel and furnish a further report on the returnable date.
Right.
How long it will take?
We are thinking about the safety also, so it will take some time.
3 weeks?
3 weeks. Deeply obliged, my lord.
4 weeks.
4 weeks
month
will be in
maybe.
January then, not before this.
Because safety is there required there. If they take the undertaking, then
The
no
first week-
problem.
There is no provision in the law for me to give an undertaking, Lordship. It is their duty,
4 weeks.
statutory
Yes,
duty to
statutory
carry out a
duty.
demolition.
It is
Demolition.
January
Petitioner
first.
cannot be told to give an undertaking.
demolished
Did it appear on?
Let him
Right,
show what
January
provision he's
প্রথমে
referring to.
opening একটা ডেট দিন তো
আমার বলা দরকার নেই। আমাকে তো সেফটি দেখতে হবে। ওরা যদি undertaking
ওপেনিং এ
Second,
সেকেন্ড ডে 7 জানুয়ারি
I'm deeply obliged, my lord.
But 7 January, I will not be coming.
6 জানুয়ারি দেখো
After 7.
10 জানুয়ারি
Deeply obliged, my lord.
10 জানুয়ারি one week from today. I cannot say when the appeal will be heard. They have given a report. I have directed to take steps in accordance with law,
অন্য কথা। নাহলে আমাকে তো করতেই হবে।
and they will furnish a report on the returnable date, that
Only
is
one
10th.
thing, may I get the server copy?
It will be uploaded. 10th. No.
I'm deeply obliged, my lord.
No, no. Next, Adam. Next.
Item number 2.
Just take.
Lordship, I beg to appear on behalf of the petitioner, my lord. My lord, from the last two
Position
occasions,
certificate by way of affidavit. Where is the position certificate?
they are asking for time for producing the possession certificate from the last two occasions. This is the third time, my lord.
Possession of the plot was not made over to lessees. Your case is that since the possession was not made over, you could not make construction. They say that possession was delivered. Where is that certificate?
I could not gather this ultimately gather this paper by specifics of paper. Kindly see. That I can find an evidence also in that regard. Kindly see. On 15 October 87. On January.
15th September.
15 September 87.
Timothy,
15 October 87. 10 September there is a letter registered for. In spite of that, they have not.
Again,
Category says you have.
they are again taking the same plead, my lord.
Have not taken any.
My lord, for that, my lord, kindly cease.
That is why, my lord,
whereas
Not taken
notice
steps.
allow me to file one
to complete.
Matter can be heard out. Later matter.
Oh. The plot by 15 October 1987 at the latest. It's a date. Physical poison plot. The other formalities have been complied with.
My lord, may I, my lord, they are referring to the which letter, my lord, if I may ask this question.
10 September
My
1987.
lord, kindly comes to my lord page 43 of my writ application. Kindly, my lord, for my satisfaction. 10 September, and my lord, kindly sees the date, my lord, of the letter. My lord, it's 13th October. After September, October, my lord. They have sent the letter, my lord. Precisely, we have paid entire amount and given this letter, my lord.
43.
Your lordship.
Dear sir,
And
with reference to your letter 204, correct?
they are taking this plea that we are not taking any steps for the possession, my lord.
Or what is this? Read this letter.
Paragraph 3, my lord. The Assistant Registrar Kalyani has been requested to hand over the possession of the plot. This is my case, my lord. We have taken steps, my lord, and after that also, my lord, I do not know why, my lord. There are several communications. In every communication, my only prayer was to kindly hand over the possession.
Listen,
Because if the possession is not given to me, how I will obtain sanction plan from the concerned municipality? And my lord, from the last two occasions, they are taking this
Tell
plea.
me whether you have satisfied or you have followed the formalities that is given herein.
Lordship,
This
my
has
lord,
been
before taking possession,
complied with.
before taking possession, my lord, there is a general rule, my lord, that we have to comply with two things. First of all, my lord, we have to enter into an agreement, lease agreement, that is with me. Second is that we have to pay the entire amount. That both the things we have done, and after that the third thing also we have done, that we have given the letter and requested precisely to hand over the possession.
Lease deed executed.
Lease deed, my lord, in the Kalyani township, my lord, there is two types of lease, my lord. First is lease agreement, and after everything is done, then lease deed is done. Lease agreement was entered into. They have directed to give the salami amount. They have directed that we have to give. We have paid the entire salami amount, and page 43, which I was referring. After that, we have also complied with the next formality.
And the B1B, this rent, annual rent, this has also been paid.
Lord, everything, my lord. If it is not paid, my lord, kindly direct them that after this letter, my lord, any letter, if they can produce that we have not paid the rent. Everything complied. After that, we have sent the letter that kindly hand over the possession to me, so that other things we can do, and request the municipality to give the sanction plan. And after that, my lord, lease deed will be executed.
Illegally as a successor. Original affidavit, certificate.
From the last occasion, they are saying that they have handed over the possession. Now they are saying, my lord, they should hand over the possession. Then only I can proceed further with my lord. Lord, I am confused. Which letter, my lord?
This letter.
Of?
This letter, 10 September 1987.
Yes, my lord, after 10 September, after September, October comes, my lord. October letter, my lord, I am producing before your lordship.
Yes.
It is with their record, my lord, and I have annexed, and it is second round of litigation, my lord.
Which is the earlier order?
You don't know about this letter, sir.
Why you don't know? It is your
Because
department's letter. Now you are producing it.
They are difficulty whether object most by department.
My lord,
This can be resolved. You find out whether they have complied with your letter or not. If complied, it is your letter which says that
lordship.
it is your letter in 1987. You have issued it that if you comply such and such, possession will be handed over. You fix a date. You have directed the assistant engineer, estate manager to fix a date for delivery of the possession.
Lordship, kindly allow me to file one small affidavit in
My lord, already affidavit.
this document.
Which document?
This big document.
You have filed your opposition.
Lordship.
No, I filed it.
Report, my lord, report.
Where is that?
Allow me to file opposition. That is
My lord, may I humbly say, my lord, what
they are sleeping night.
my lord, what document they are referring? They are referring of September 1987, and I am producing document October 1987. I am producing. If handed over to any document must be there to corroborate that argument, my lord.
Has been allotted to him. Thereafter, repeated requested there. It could register later, but they failed to comply.
Then what October 1987 is saying, my lord? If they are referring to September 1987, I am producing October 1987. After that, any communication, if they can show, what they will, my lord, they are taking this plea that on the last two occasions they are saying handed over the possession. Now they are saying, now also in before this honorable court, they are not able to produce the possession certificate. Whether they are admitting that they have not given the possession certificate. If they are admitting, no question of handing over the possession certificate. What I have not followed. October letter is with lordships. In my writ application, I have annexed. What more can I do, my lord? My lord, we can only do all the things which are required me to do, and I have done that. They are producing September letter, and I have annexed October
Produce the possession certificate.
lordship.
I have to file on affidavit. Stating all that why it has not been used.
Produce there. There was a direction to produce the certificate of possession by way of opposition.
This document was not.
No. There was a direction to produce the possession certificate by way of affidavit.
Lordship.
Where is that affidavit?
Much correct.
That is what I
Either you say that yes, possession was delivered, this is the document, or you say that possession was not delivered. If the possession was not delivered, then he has a case.
Much correct.
If the possession was not delivered, then he has a case.
And my
If
lord,
it was delivered, then he has no case. This is the thing.
most humbly, my lord,
If he complies, then 1987 there has to be delivery of
Lord,
possession.
that has to be under the-
To ascertain that,
my lord, already, my lord, second
Mr.
round of
Pantu Dev Roy, learned advocate for the state respondents. This copy has been annexed to the writ petition.
lordship.
204
Which
produces a letter under memo
Let's
number
is not annexed.
204/B10/129 and Roman 1 छोटो हाथेर and 130 dated 10 September 1987, which is taken on record. He submits that notice was given to the predecessor in interest of the petitioner to comply certain formalities and for taking over possession of the plot.
My lord, my letter is at page 43 of my writ application. It is of
Mr.
lordship.
Sundip Ray, আচ্ছা ওরা পণ্ডিতদেবরা আর একটু করে নিন যে he seeks accommodation to produce the possession certificate by
Lordship.
way of affidavit. Mr. Sundip Ray, learned advocate.
Filing affidavit, why they have not, why not?
No. First you produce the
Lordship.
certificate.
No, they have to, yes, that is with us. Definitely, if they not.
First you comply the order of the court, produce the possession certificate. That will be sufficient to find out whether they have been delivered or not. Sandeep, learned advocate for the petitioner, submits that pursuant to letter dated 10th September 1987, all the formalities have been complied by the predecessor in interest of the petitioner. In view of the above, state respondent is directed to produce the possession certificate in terms of the direction of this court video order dated 16th May 2024 by on the returnable date. 2 সপ্তাহ পরে কবে যাবে? 16th.
Much correct.
এই কপিটা দিও।
Much correct.
Item number 3.
3. Why? It's been filed for determination of the Monday. Yes. What is this?
Sorry, instead of 16, it was 17. If you look.
Ask him.
I will.
What is it? 17th round.
Keep looking.
You have filed your opposition. You have filed your opposition. Affidavit in reply filed on behalf of the petitioner.
The officer they have admitted, my lord. I mean, trying to get the compensation according to present market rate, but there is a
their admission. I am ready. Get the compensation.
Then dispose it off.
My lord, next day, sir. Next, my lord, because my lord, deep is not here, my lord, without intimation, my lord, matter is appear, my lord, people are not saying, my lord. This is a direct purchase policy. I am ready. Get the compensation of the direct purchase policy.
They are ready to direct.
Yes. That is an admission in the opposition. You come on Monday, my lord, you have to fix the matter on Monday.
Next Friday রেখে দেবো. Evident reply filed on behalf of the petitioner is taken on record. Mr. So and so, learned advocate appearing for the state, seeks for short accommodation. Friday কত তারিখ? 5 6th. 6th.
আপনার নামটা কি স্যার? আপনার নাম? স্যার, Friday, next Friday.
Next Friday is 6th. Next Friday is 6th.
This was it.
December.
Yes. If it is not fifth, the next sixth, I have another matter. The fifth.
If to the
Fifth.
if to the fifth reach করতে পারো.
Fifth.
Fifth.
Yes.
Number 4 and 5. To file কি একসঙ্গে দেবো? একটা পাশে রাখি। Item number 4 and 5.
For the registration, item number 5, I appear for the KMDA in both the matters, 4 and 5, concerning the same.
5 who is for the petitioner?
One for the private responsibility, the other.
No, 5 you are the petitioner.
5 I am for the petitioner.
20903 I am the petitioner.
Okay.
1387 I am the private responsibility.
In my matter, my learned friend has filed an application additional party. This is my opposition, my lord.
তাহলে এটা কি মানডে তো নেব? হ্যাঁ আজকে এসে যাবে?
হয়ে গেছে তো ওটা?
হ্যাঁ?
হয়নি? হ্যাঁ? My lord, I think
there is an
subject to correction, one substitution application has been filed in
That is within time, my lord.
to 2-1. That is, I
Can
think,
do.
item number 5.
Can
5A.
put আছে? And your application for addition of party?
Satisfied with W32137 scan.
Then what is your substitution application?
Substitution, my lord, the petition number 1 died. Other 2 persons are there, my lord. Other 2
এই
petitioners.
দেখো না লিস্টিং এর গন্ডগোল হয়েছে, সব ক্যানগুলোই একটার আন্ডারে দেখাচ্ছে, দুটো ক্যান 2 আছে। Mr. Banerjee, you have filed your application can 2 of 2023 in WPA 21387 for addition of party. And can 2 of 2023, this is your application in 20903 for substitution.
21387.
Your application is 2
It's my application for recording the death.
and your is
My application for can 1.
can 1.
Can 1.
Can 2 বলছি।
Can 1, it is, yes.
Can 1 এটা জানি না।
21387.
আচ্ছা এটাকে not to দেখবে। The applications are not there, so making it not today, on Monday I will take this application. এটাকে application এর heading এ দিয়ে দিও, তাহলে Monday তে হয়ে যাবে।
দাদা এটা স্যার
বার করে টাইপ করেছি।
next day.
Next.
Item number 6.
Okay.
Sorry,
No, ask.
As per your lordship direction, my lord, I have applied for the certified copy, my lord. This week, my lord, the estimator is done, my lord. My lord, perhaps today I will receive the copy of the certified copy.
On the prayer of learned advocate for the appellant. 2 weeks. On the prayer of learned advocate for the prisoner. Acha, na. Mr. Anirban Sarkar, learned advocate for the appellants, informs the court that he has already applied for getting the certified copy of the which decree.
Decree also.
Decree. But the same has not been delivered as yet. He seeks for accommodation. 2 weeks after winter vacation.
My lord, one small injustice, my lord. My lord, next month I have some personal difficulty, my lord. Next month, my lord, December, my lord, I have some personal difficulty, my lord. My lord, kindly fix it after vacation, my lord.
2 weeks after winter vacation.
2 weeks after winter vacation. I'm grateful, your lordship. I'm grateful, your lordship.
Item number 7. My lord.
Yes.
Number 7.
Yes, for the corporation.
I am for the petitioner, my lord. My lord, this is my lord unauthorized construction building, and I raised complaint. My lord, inspection was held. Opportunity hearing was given to all the parties. I produced all the documents, and also respondent has produced all the documents, but they could not satisfy the authority that they obtained the sanction plan. Accordingly, my lord, they did not obtain the sanction plan. Accordingly, order was there for demolition of the property, but they did not, my lord, personally demolish it. Corporation person in there and also demolished part of the portion. Part of the portion is left remaining. That's why, my lord, I humbly prayer before lordship. Let
For
the
7 to 8 days we demolish.
entire portion be
7 to 8 days we demolish.
My lord, kindly. No, my lord. I have filed my exception. The lordship kindly come to exception
Wait.
3.
Yes, Mr. Banerjee.
7 to 8 days, I have written in my report, 9/11/223 to 11/11/223, we have demolished, debris cleared thereafter. After demolition, debris have normally stacked, we have cleared. 21/11/23 to 23/11/23, we successfully have demolished the portions of unauthorized construction with the help of police force. Now, my lord, we have stated, my lord, if your lordship goes through my report at para 10, my lord has got it. One-story residential building was as a state of under construction in which petitioner constructed 8 number RCC columns with lintels, beams and roofs, shuttering with reinforcement and outside brickwork. This portion had been demolished, fully area 60 square foot, only in 11 my lord it is written. At present, only a temple portion 20 square foot exists, which is Radha Madhav Mandir, my lord, there is. This temple is an unauthorized, we cannot deny it, but it is in an unfinished conditions. Works of flooring and other finishing works have not been done there. It is a Radha Madhav Mandir that is remaining.
My lord,
The temple of 20
My lord.
remains in the whole structure, my lord. Otherwise everything is gone.
My lord.
My lord, even my boundary wall.
Now they
is
says,
not
now they says that the Radha Madhav Mandir is required to be demolished fully.
my lord, there is no murti
Their
or idol.
contention.
No ceremonial, my lord, ceremony has been conducted there. No
This
murti
will
or idol.
not cause any problem to
This is
anyone.
not only another structure, my lord. While my lord constructing the structure of the building, this has also been made. So, my lord, there is no question of my lord idol or mandir. Mandir, my lord, there is no establishment or no my lord placement of the any idol or murti is there. my lord, so my lord, according to law, my lord, your lordship kindly pass
Yes.
that.
Any inspection may be done by the special officer that can.
Specifically mentioned from the deed of partition, my lord, from where my lord the title is devolved upon all the my lord parties of this my lord instant application for your lordship. That there is a structure, there is my lord a structure, my lord, where my lord the worship is being carried on, and my lord it initially my lord it was a devoted property, my lord, but that is my lord still followed. And my lord kindly considers my lord my entire demolition,
No.
But one thing, my
If-
lord,
if this is-
even my lord my boundary wall is no.
agreed, my lord.
No.
Suppose my lord, supposedly
One thing, my lord, we have gone to demolish the Radhabandha Mandir, but there were many people are there, so only problem is this.
Of temple.
It is a religious
Nothing.
temple.
They have already admitted, my lord, this is also.
You are a
an unauthorized-
co-sharer.
They have also, my lord,
Yes, yes.
He is a co-sharer.
I am co-sharer. I am co-sharer, my lord. I have also filed my, my lord,
My lord, suit
record of.
See,
on
if
their
this is a
My-
temple, then there might be some issues relating to if it is a
Yes,
joint
religious issue.
temple of the family.
My lord,
That will
the
be a
temple
difficult.
was there, my lord. I frankly submit your lordships.
Let them
Let-
demolish
let-
it.
I firmly
Let them
firmly
demolish.
submit your lordships. There is no temple at all.
Let
This
them
was, my lord, just merely a structure in the nature of temple.
Let them
That
demolish.
merely it has no
As
bodies
Kansa,
there.
you have constructed it.
Yes, they have constructed. Merely that in the nature of temple, but no idol is there. There is no such temple is there, my lord. There is a vacant position. There is a vacant position.
Para
They
people are
started,
also
my lord,
going there. Dharanna. Para people are also going there locality and
So, my lord, humbly plea, my lord, according to law, my lord, your lordship, without sanction plan, even the temple or building, whatever may be, it is not at all temple, just like a temple, but in the nature of temple, but it is not temple at all.
and only humble
There
prayer.
is no idol, no
your
idol,
lordships,
no murti, nothing.
Only humble prayer before your lordships from the corporation. If your lordship so desires, the temple is required to be crushed. We will be there, police will be there. Let them come with their labors and everything, and let them demolish. We will not touch. We cannot. Actually, there are many dharmic people in our demolition squad also.
The special officer filed a report
Right.
as to the status of the whether it is used as a temple or not, or just a temple has been,
Yes.
whether idol has been installed or not. All this.
Yes, my lord. Good.
Ashun. Mr. Sondipon Banerjee, learned advocate for Howrah Municipal Corporation, respondent Howrah Municipal Corporation, 407, referring to
ওনারা ভেঙে দিই সেটাই বলি। ওরা গিয়ে ভেঙে
its report, submitted that the entire structure as complained of has been removed. Only a portion of the temple measuring 20 square meter exists. Mr. Ramchandra Guchait, learned advocate for the petitioner, submits that the temple is just a structure and there is no idol in the temple. Hmm? এর remuneration কি হবে, কি special officer হবে? You be the special officer or you are with him? Who will file report? একজন কোন advocate কে special officer করে বানিয়ে। You will be there? You will act as a special officer? He is empaneled with HMC?
No.
What is your name? Mr. So-and-so, learned advocate. You are in Bar Association? Member of High Court Bar Association, is appointed as a special officer who shall conduct an inspection as to whether the temple portion as depicted in the report is being used as a temple or not,
and Radha Mandir Murti is there.
and
Any
whether there is
idol was-
installation of any Radha Madhav,
an idol or any
idol in the temple or not, and furnish report on the returnable date. The remuneration of
payment is to be made by the petitioner.
না না ডেট কেন কত হয়ে গেল রেমুনারেশন স্পেশাল অফিসে 5000 করে 5000 টাকা ওয়ান ডে তো 5000 রেমুনারেশন
I could much more is required because normally 20 to 25,000 is given.
20,000 20,000
Petitioner will pay it,
which shall be borne by the petitioner.
and only time and date may be fixed, my lord, because in that case I will also ask my officers to be present.
Such inspection shall be conducted in presence of the officers of Howrah Municipal Corporation, the private respondents as well as the petitioner.
Date and time be given so that no notice may be required.
The date and time of inspection shall be fixed by the special officer as per convenience of the parties. He will give a notice. I am not fixing any date. As per convenience of the parties, he will give us.
Gives here, then it will be better. No notice required to be given then.
The thing is, if I give a date and the special officer faces any problem on that particular date, then he has to come up to the court and say that kindly change the date. As per your convenience, you give a notice to the other side. As per their convenience, fix a date and cause an inspection.
As your lordship.
Is this matter after return করে দিন 2 weeks পরে 2 weeks
2 weeks after vacation. If it is 2 weeks after vacation.
2 weeks after vacation এই সমর্পিত আপনি হ্যাঁ ও হ্যাঁ জিএমসি বলে এটা হিসেব করে আপনি না
My lord,
yes
your lordship, my lord, till today there is no such idol. I am, my lord, humbly submitting before lordship. If within that time, my lord, yes, my lord, your lordship can record that. But within that time, before my inspection, if they could do so, then my lord, I will be my submission will be in force. So till today, my lord,
How can my lord, my learned senior, my lord ascertain that, my lord?
no, my lord, we are, I am.
don't complicate the matter Mr. Guchait.
Yes, my lord.
The report was filed on. Now a learned advocate has been appointed to inspect the
28
Temple.
2004. 2024.
There is no
20 August.
There
We
is
have
one,
gone
there is
there
no
and
such
now
written.
there
There
is
is
an
no
idol.
such
Now
written.
they are
It is
saying-
only written as Mandir, but
No,
no
no,
idol is written there. Whatever may be, my
Let
lord,
him
as your
inspect.
lordship directed,
Let him
let them-
inspect the
Okay, fine.
Now they are saying that today there is no till then if there is, it is installed. Now they are
face any problem you come to the court.
confused.
বলছি যে
Yes, my lord. Peace after vacation.
Item number 9,
পড়ে দেখবেন কিছু গ্যাপ থেকে যাচ্ছে যেটা ধরুন মাঝখানে একটা ওয়ার্ড গ্যাপ থেকে যাচ্ছে ওর মিনিংটা পাল্টে যাচ্ছে এটা আপনি নিজে পড়লে বুঝতে পারবেন যেমন কি ঠিক আছে
item number 9,
9 Oh. Whether any probate proceedings has been initiated. Mr.
extension of the report given to us.
So and so seeks plenary advocate for the petitioner seeks extension of time to file supplementary affidavit in terms of order dated 3rd May 2024. Please this matter 2 weeks after the winter vacation. 2 weeks after winter vacation. কত নম্বর ডাকলে 9
Item number 10.
There was a time to file exception on the yesterday matter was called on.
দেখি কি দেন
Exception টা file করে দাও।
extension file exception. Where is the exception? Huh?
Several locations they have taken time to file that.
Where is the exception? Doctor to pass over.
Pass over.
Hi. Daddy. What is this matter? Bandyopadhyay? This is of
Matter, my
compensation.
lord, the relates to land acquisition for National Highway Authority, my lord. The land acquired in the year 2011. 14.5 decimal of land, my lord, was acquired for widening of the 6th lane for National Highway Authority. When the original, my lord, landowner Sorojit Vishwas, he might not obtained the, my lord, the compensation which was awarded by the competent authority. And it is paid to the, my lord, the Sorojit Vishwas on 1st February 2013.
Okay.
Thereafter, he never filed any application for arbitration. Although, my lord, arbitration held, arbitration notice was sent to him, my lord. Your lordship kindly turn to page 34, P4 of the
Yes.
notice for arbitration to Sorojit Vishwas.
At whose instance this has gone to the arbitration?
Thereafter, my lord, arbitration held, arbitration award passed. He has received the amount. P5, next page, my lord. Payment notice for arbitral award. Payment notice of arbitral award under section 5 of the National Highway Act. Sorojit Vishwas. Payment made. Now the petitioners here come before this honorable court to pay, my lord, your lordship, kind of prayers. Adequate compensation.
Who is this petitioner? How is he related to Sorojit? Petitioner is related to Sorojit?
Yes.
Oh, legal, yes.
Yes. Wife and my son.
Oh.
Yes. Petition is not at all matter.
Regarding the portfolio of the adequate compensation. Here is, if they were present market value, this submission, this prayer is totally contrary to the National Highways Act. Totally contrary to the National Highways Act.
How?
After completion of the arbitral, there is a provision of appeal under section 34 of the Arbitration and Conciliation Act, my lord. And they made representatives after all times are already lapsed. Therefore, my lord, repetition is not at all matter.
That arbitration award can be challenged under 34,
Can be challenged under section 34 of the Arbitration Constitution.
not by way of a writ petition.
But here, below, they mentioned that the present market value we cannot be, because as per the National Highways Act, when the date of publication of the notification, from that date, no lordship, when that is the date, from their calculation of the compensation, not from the present market value, which is mentioned in the National Highways Act. So such here is totally contrary.
We have filed our report, my lord, it has been all stated in our, my lord.
So one aspect is that after adjudication, payment has been made. Second is that market value, prevailing market value will not be there. The notification date of 3A will be the market value. And the other aspect is that award cannot be challenged before the lead court. Yes. Tomorrow, yesterday also this happened. I made it not today. I asked you that you come with your whatever exception you have to find.
On record, Mr. Shamimul Bari is engaged in photo number 2, my lord. Pass on.
And I am disposing it off. Either you submit or pass over. How? This is 12. If the advocate is not interested, then I dispose of this writ. Every day this cannot go on, madam. Yesterday I accommodated you, making it not today. I gave you time that you get the exception, at least file the exception, let them go through the exception. That is also not filed. The conducting advocate is not here. He is busy in other court. Is the petitioner's advocate interested to pursue the matter? Get habituated in getting adjournments. If you want to submit something on behalf of the petitioner, submit. I'm ready to accept that. But no passover. You make your submissions. I note that and dispose of this writ petition.
Knowledge about
What prevented you to go through these records? Yesterday also I gave you time. Who is appearing for the petitioner?
and for the
It's appearing on from there.
Who is the advocate who will conduct this case?
Yeah, Sutroder advocate on record.
Yes. इनको सर्च करो मुश्किल. You go through the records. At 12, I will take it up. Either your senior comes, fine. Otherwise, you make your submissions that these are the case of the petitioner. Get the exceptions. Exception is ready. Pass over. At 12, passed over for 20 minutes. You go through the records, make your submissions. Pass over about some time.
Item number 11.
I'm for the petitioner. Lord, that matter, my lord, you lost it.
Yes, my lord, yes.
Last
My lord.
What happened?
Lordship, my lord, I'm tendering my apology. My lord, the Kala has of the SPO Murshidabad Lordship has represented to the National Highway the facts that there is no need for any Form 2B in this present case, since the declaration, the clarifications of this land in mentioned in this 3D notification is mentioned inadvertently as Amon instead of VT. So in case Form 2B is required in those cases where there is a change of class of land with the recorded class of land. Here there is no class of land is there. Only the clerical mistake, because of this clerical mistake has been mentioned as Amon instead of VT. So, my lord, for this clarification, my lord, they have already intimated us. Lordship, give me, Lordship, 4 weeks time for this approval, Lordship. There's already been, Lordship, almost all these things are done, my lord. Only for these certain clarifications, Lordship, they have sent us, Lordship. So, we need 4 weeks time, Lordship, for start taking a decisions regarding this, man. Only 4 weeks time.
Ms. Monica Roy, learned advocate for NHAI, submits that a further clarification is required from the department. He seeks 4 weeks accommodation. Is this matter 1 week after the winter vacation? You will file that clarification. Later come up with the clarification.
Yes,
It's
my
a
lord.
matter after that.
Grateful to you, Lordship.
Already been, my lord, they have, my lord, assessed and valued amount.
Yes,
They have
all
already
done. Only
What
for
is the
certain
clarification? Let us see after the winter vacation, 1 week after.
Item number 12.
What is this can 1? Can 1 কি dispose of হয়ে গেছে? Can 1 টা কি আছে? লিস্টে দেখাচ্ছে
My lord,
12 ডাকলে না 12 তো।
here is, I will reply.
12 এর নিচে যে can 1 কি দেখাচ্ছে? আপনাকে জিজ্ঞেস করো না can 1 টা কি আছে?
Canon for the early hearing. It's filed for.
Early hearing?
Yes.
নিয়ে নেবে যদি hearing হয়ে যাচ্ছে দিয়ে cold fields কাগজ ধরো yes
Well, petitioner, forefather is the owners of the land, and he has purchased the land from the then Maharaja of Bardhaman. And recorded his name.
yes
Thereafter, they are reserved the property to one Afshar Colliery. After Colliery was recorded his name, the record of rights. I have annexed the record of rights, my lord. Some of the record of rights I have annexed. My affidavit, my lord.
Which should not interfere in the matter, Lordship. Your Lordship is taking up the writ petition of 4177.
Yes.
Lordship will kindly see the prayer of 4177. And Lordship, paragraph 15.
Of the petition.
an application
Injunctive prayer for a legal proceedings. Prayer. Injunctive prayer for a legal proceedings is the prayer. And in para 15 is the similar cause of action. This is my preliminary objection.
That's against the vested of the land, and
state order
this is the acquisition of the land without giving any notice. Without giving any notice, then acquisition my land.
so that earlier writ petition is pending.
That writ petition is also pending.
Cause of action is different.
That is against the vested of the land. And this is the acquired the land by the Eastern government without due process of law. They are not giving any compensation, they are not giving any notice also.
Okay,
I have my.
They have given notice, some
copy, if
other
your
person.
lordship so desire, I can.
Give
It's
them.
little mark.
See the prayer in there. একটা কি আছে? So in one, the vesting has been challenged.
Yes, my lord.
In the present writ petition, respect of the same land, you are,
Land.
yes, same land,
Not same land.
yes. You have sought for an injunction. Both must be heard together.
So, but then what is the injunction he is saying? He is saying that.
But my lord, one thing. I have already not pressed that application and that application was dismissed, but not pressed.
Sir, why the other side has to indicate that? Why didn't you at the outset submitted that that has been not pressed by you? Where is that order? He says that it is pending and your writ petition also.
I might be sorry, my lord. To my knowledge, I
at
have not.
At the time of filing,
দেখো,
Separate,
when it was not pressed, when it was not pressed, দেখো তো order.
আগের writ petition এর নাম্বারটা
ওটা আছে। আছে।
এটা না, এটা তো ওনার কপিটা দিয়ে দাও। বলছে কবে নট প্রেস করেছে দেখি। না, নাম্বারটা পেয়ে যাবে। ওনার কাছে নাম্বার, ওনার কাছে ডেটটা নাও কবে নট প্রেস করেছে। হ্যাঁ, ডেটটা না পেলে কি করে হবে?
পার করে দিচ্ছি।
ডেটটা না জানলে আমরা এখানে
When it was not pressed.
If it is not placed, lordship, then I will come. Order 23, rule 1. If the liberty is not taken and not placed, then lordship, the second writ petition remains registered.
No, he filed his application while that was pending.
Yes.
During the pendency of both the applications, probably he sought for withdrawal.
All right. So moment he withdraw, that means that particular matter, all cause of action relates to that land is withdrawn. If the liberty is not taken, he cannot file afresh. So now can I put a question to myself? Can someone take a liberty? Order 23, rule 1, if I withdraw, I cannot file. So as I know that I will not get the leave, so I will file and then withdraw. Then there is a suppression and it's a, I should not use the strong word, but it is a surreptitious way of bypassing the leave. That should,
Yes.
no, I did not want to use that. I just.
What is that order?
Stated it is not suppressed.
Again, none appears on behalf of the no accommodation sought for.
Have it suppressed.
He didn't move the application.
I'm sorry, my lord, the order seems
Dismissed for default.
It's not even withdrawn.
So we've allowed it to be dismissed for default and move this application.
you know, appear this matter because that matter is not. And that is a completely separate matter.
At case you have to place that writ petition before the court that this is the copy of certified copy of the deed or this is the true copy. Cause of action is different, then only we can. But to my understanding, after reading both the two prayers, I found that both are same prayer. One where he said that this has been vested by without following a due process of law. I have not received notice. This and that. He has got 30 grounds. Now, lordship, in the other matter, he's saying injunct him from acquiring. So if I give a very liberal interpretation to it, that injunct means he is saying stay of the proceedings of acquisition. I put it like this way. If I give all benefit to my Lordship, even in that case, Lordship, then he has to indicate which acquisition case number he is trying to get a stay over. That is not indicated. He said, I am the owner of this much of land.
They are not given any notice till today,
I understand.
but they have by force acquired my land with the help of the police,
Lordship, this is
and they are cutting the coal.
this is
Till now.
very statement which is absolutely do not go with my client and my learned friend's client, because I am a central government PSU and my learned friend is the state of West Bengal. So we cannot, we will never enter into someone's land without following the due process. Now he says that I have entered and obtained coal. If it is there,
But they are
So
not given notice. They are not only
the
entered,
coal, the
they are
owner of-
already by force acquired the land and cutting the coal. Still now,
They're extracting the coal.
when the petitioner went to the police
Okay,
said, I have
Mr.
not.
Banerjee, you continue. Let me hear it.
Pilot, may I give the date? May I be allowed to?
No,
It is- It is.
Let him, any one submit, otherwise I cannot follow. Yes,
Fifth,
submit.
5th of February. It has.
So the earlier one, earlier read petition is dismissed for default. It's not withdrawn.
It is clearly stated. Yes.
Yes.
Petition is the possession of the land, and by force they have acquired the land without giving any notice. And when they went to the land, the petitioner went to inform the matters to the police, but police was not held. And they are already acquired and they are cutting the coal till now. But
Without.
CL have no power to acquire the land, but the bypass acquired the land and tender to some other parties. And one of the notice I have collected, that is other parties, they are.
আছে।
Under base 50, election P9, that notice petitioner collected from some other persons. Their lands are also acquired, but without any rubber stamp or without any signature, only initial signature there, nothing else.
Which are the land? Page 50.
Base 51, only initial. Who is that person? I do not know. No signature, no designation, no rubber stamp, and also not to use Krishna Coalfield Limited. That is- Including that notice, they are giving the sum of the lands, next page, 53 onwards. The two names and phone number is there, but who was there? They are not mentioned.
Hmm. Your name is in this list.
Yes, my lord.
Where is the plot number? Your plot number?
Number is my lord. My lord, page 4 of my writ petition, paragraph 2.
Who granted the lease to the leaseholder? There was a title suit between the petitioner and the leaseholder.
I just should.
What happened in that?
That application was compromised, settled, and thereafter the upside call company hand over the position. Hello, my affidavit in reply, my lord, page 77 and 77 in retype. The order in presence as JLRO. Also clarify that the petitioner's father is in possession of the land and he cultivate and fishery and crop, etc.
What is the order of the BLRO?
Of the BLO, my lord,
Trying to take up our
page 82 of the writ petition, my lord. To the reply method. Page 82 of the reply, my lord.
R. This is after the order passed by LRTT.
That is my lord, page 38. Page 38.
Mentioned in the Moja this
Or I.
state. Voting in favor of.
I am reading below, page 38. Whereas it appears that this office undersigned received on 12th March 2019 a representation of Siddharth Mondal and 3 others. Where are the present petition? The order passed on way number 3501 of 2018 on 8 February 2019. In the matter of Siddharth Mondal and others from the state of West Bengal. And whereas on scrutiny of records of right, it is found that the plot mentioned the representation in Muja Charonpur, Jail number 52, were recorded earlier in arrest petition number 198 and 251, which were intermediary Khutian and vested to the state by the combined operation of 4 and 5 of the West Bengal State Acquisition Act 1953. The Khondo Khutian number 453 opened in favor of Apkar Colliery Limited during heavy stage of the preparing record of rights. Also, all the plots are recorded in favor of the Apkar Colliery.
That line was not vested.
Pursuant to the honorable tribunal's order, the hearing was taken by the PLR. Not an impulse.
Bail order, some of the.
Now this representation includes entire land which is stated in the writ petition. It is correct. All the lands which we have specified in the writ petition.
Go to the order and they will speak on page 39, last paragraph. The case is order number 4, dated 16 May 2019. The case is taken up today for hearing. Applicant Siddharth Mondal and 3 others were all filed Hazira come to the current computer error of right. Respect of the plots. Found all the plots are recorded in the favor of the Colliery. The applicants are asked to produce valid documents in support of their claim, recording the land in their favor, but they failed to show any such document. Siddharth Mondal and others pray for time. Time is granted next day. Next day, whether they were not produced. Next, whether speaking out of order number 5, dated 65, last paragraph. The case is taken up for hearing. Siddharth Mondal and others applicant appeared and filed Hazina. They are under advocate come through the OP. First, the applicant next page here submitted a copy of the letter issued by the manager Apkar Colliery Limited to therein, though there is overwriting on the year of issue, the undersigned find difficult to understand. They failed to produce any registered deed with the plot mentioned clearly in the land situation.
The state government became the
Also comes to the written submission of the
disputed
court
land
company
as the state
limited,
courier substitution before
the
the
coal company, which assumed that the land was not acquired by the
Presumption
ECL
of
by the provision of the Land Acquisition Act of
contract is
1994, nor it has been nationalized on personal perusal of RS and Data Code of Right. It comes to it and returned to him, but he fails to produce any written document. It appears that the disputed plot has been recorded in favor of the Apkar Colliery Limited in several RS Kodiar. As it is the matters of the mines and minerals, the matter relates to the provision of the chapter 4 of West Bengal Estate Acquisition and section 29 of the Act. In this year's provision that all leases of mines and minerals in a notified area granted by an intermediary and subsisting intermediary before the date of vesting, with effect from such date,
The deed to have been granted by the state government to a holder of the state substitution on the same term condition and substitution. Hence, it is clear that the state government becomes the lessor of the disputed land and the colliery is subsisting before the date of vesting as well as after the vesting. So the issuance of the resumption of such colliery land by the other and the state government is contrary to the section 29. Of the state petitioner. Copy of such resumption of the coal company has been produced by the applicant, but it is revealed that the year of the state letter was found not clear and overwritten, and it was obviously made in the contravention of the chapter 4 of the said act. Hence, the claim of the recording of the land comprising mentioned generals covered under section such and such in favor of the petitioner is not maintainable in the eye of law. Furthermore, the undersigned has also gone through the order in respect of the case number such and such, wherein the state government has not been made party. Therefore, the state government could not defend the case. The order of the London District is not binding upon the state and has thus disputed ought to be reviewed by the state government as per clause 2 of section 29 of the West Bengal Act. District Act. The applicant furthermore who do not produce any valid registered documents with the land in support of the claim, hence the application is disposed of and prayer is rejected. Therefore, it is clear.
My lord.
Thereafter, when the inquiry head, and it is found that my lord, part 2, inquiry held on page 7 of my report. It is the inquiry.
Yes.
It is held on my lord 7th March 2024. WPA in connection with this my lord WPA number 417. আপনার নির্দেশন তার 24 তারিখে চরণপুর মৌজার অন্তর্গত দাগ নম্বর 55 অন্যান্য দাগগুলি সমিতিতে তদন্ত করা হয়। তদন্তের পূর্বে উভয় পক্ষ অর্থাৎ সিদ্ধার্থ মন্ডল এবং মিস্ত্রের কর্তৃপক্ষকে নোটিশ প্রদান প্রেরণ করা হয়। তদন্তের সময় মিস্ত্রের কর্তৃপক্ষ সিদ্ধার্থ মন্ডল উভয় উপস্থিত ছিলেন। তদন্ত সময় যা দেখা যায় তা তদন্ত বলে দেখা যায় দাগ নম্বর 57 দাগগুলি ইসিএল কর্তৃপক্ষের দখলে রয়েছে এবং বর্তমানে খনন কার্য চলছে। দাগ নম্বর 57 অন্য দাগগুলি ফাঁকা ও পতিত অবস্থায় রয়েছে। তদন্তের প্রতিবেদন আপনার জানাতে।
So the land of the petitioner is Khaw. It comes within Khaw. It is vacant. No, the land within Khaw is 53, 54, 55, 56. This is
My position. The entire land is in my possession.
Presently their position, my lord.
so Apkar Colliery, thereafter it became ECL, or ECL has taken over from.
And it takes up my report.
After colliery Hyderabad the position, my lord.
Prior to that, what was the prayer in the title suit? Who was the parties? The petitioner was the plaintiff. And
Apkar Colliery and
Yes, Mondal is the chairman. Father of Mr. Mondal,
Equitable Coal Company and Apkar.
Father Mondal.
okay,
Lordship, let's proceed like this. Whatever he is saying is correct. He is the owner of the land. He is in possession of.
Yes.
He is owner of the land. He is possession of the land, and he is having all right title interest on the land. That can be his best case today. Now, if I apply that best case from his own averments, found that from Maharaja of Bardwan.
Yes, I have annexed the documents on evidence.
sir, allow him to submit now. You have made your case, let him submit. Yes.
From Maharaja, it has come to him and him to two collieries. So we have, this is not his case that all along he was in possession. Once he filed a suit in 1964, that means the colliery, Apkar Colliery and Equitable Coal Company. Apkar Colliery gone into liquidation and equitable coal company purchased it. So admittedly, some colliery was there on the possession. So now anyone is on possession on a particular date of 1973, whether he is under lease or under any arrangement, any mining activity done on some place, and coal, because owner of the coal is Government of India. Whatever he is doing, say that I have right on Dag number, Mauja number, whatever, is the surface right. Geological right is always with the government. Even if today someone finds some petroleum under my plot of land, my land goes. So, Lordship, the law stands like this. On the particular date of 1973, Coal Nationalization Act has come into play. Any colliery wherein its adjacent land, not only where they digged coal, but any adjacent land where they kept their shave, machinery, storage of coal, enter this will be vested in Government of
What is that act? Colliery?
that. I have an expert. Lordship will find that is called Coal Nationalization Act 1973. Lordship, I have also annexed. In 1973 Coal Nationalization Act, Lordship, we have given the detail of all collieries as far as possible. Charanpur colliery, Apkar colliery, whatever, because Charanpur was the law. So we have given, and then that stands vested on. So what he says today, he is probably trying to visualize a LA case, I mean land acquisition case, to be instituted against him, then it has to be done, notice to be given. No. Let's understand that the perception of the petition in this matter is wrong. On a particular day, when an act comes into picture, everyone becomes the government. Same thing happened in the insurance.
You take me to the provisions of
Lordship. Lordship, kindly come to page 54, 53 of my report. Lordship has
Yes.
53.
Yes.
53. My lord, kindly see on the right hand top, 30th May 1973 is the Coal Nationalization Act, which has come into. Now, Lordship, we will try to see the object of that. An act to provide for acquisition and transfer of right, title, interest of the owners in respect of the coal mines specified in the schedule, with a view to reorganize and restructure such coal mines as to ensure the rational and coordinate and scientific development and utilization of coal resource consistent with the growing requirement of the country. In order that the ownership and control of such resources are vested in state and hereby so distributed as best to subserve the common good for the matter connected therewith or incidental there. The Act of Parliament is this. Lordship, the declaration as to exigency of the Union Contract. It is 1A. It is hereby declared that it is expedient in the public interest that the Union should take under its control the regulation, development of the coal mines to the extent hereinafter provided such and such, such and such. The declaration contained in addition to and not in derogation of the declaration contained in section 2 of the Mines Act, Regulation 1957. In the Act, unless contest, the appointed day is the first day of May 1973. Coal mines means the mines in which there exist one or more streams of coal. Company means such and such. Now, Lordship, kindly turn to the next page and come to the mines. H. Page 54, Lordship. The mines includes words. Lordship, kindly see. The mine means any excavation where the operation for the purpose of searching of the coal obtaining mineral has been or is being carried out or included. All boring, boreholes, shaft, whether in course of the being sunk or not, all levels, inclined planes in course of having driven, all open cast working, all convey and aerial ropeway provided for bringing into removal from the mines of the mineral or other article for the removal refusal. All land, building, walks, adis, level, planed, machinery, equipment, instruction, store, vehicle, railway, tramway, sliding or adjacent to the mine used for the purpose of. Lordship, here many people think that the mining was in this place. I had a ropeway that place, or I had a mining bungalow that place. That will be excluded. So we often get a request from many owners that you kindly leave that. But the Act says not only this, anything you used in aid of your mining, be it is a ropeway, be it is a washery, or be it is your bungalow outside, all will vest. So Lordship, many a time, because many a times it happens, there are two types of coal mine. One is the open cast, and other one is the closed, means bearing. We go inside this. Then there is a hole, we make a huge hole, we take out the coal, we fill it, and then we pillar it. But the surface right remains clear. In that case, what we do, if there is any subsistence or any surveillance, what we do, we purchase the surface right from them separate. But in this case, as it was already acquired, we have three types of land. One is we acquired a land through LA, Land Acquisition Act 1948. I can acquire a land for my emergency under CB, Coal Bearing Act. I can acquire under Coal Bearing Act. I can acquire under Land Acquisition Act. And these land banks are my vested land banks from 1973. So I started my business from 1973. The government of India started its mining operation in 1973. With this become vested. So this is my primary land. We say this land is Schedule A land, and then what we keep on acquiring is Schedule B and Schedule C. So Lordship, by operation of this, if I don't go into any disputed question, because I am in a writ court today, even if I don't go into a disputed question, his own admission is that colliery was present there. Now, if the colliery is present there, or a coal activity has been already done, that is undisputed to him, then by operation of this law, I become the owner.
Okay.
So,
And as per the order of the BLRO, this land was vested prior to 1973.
Now, Lordship, what I'm saying is, even vesting is done by a state law. I'm arguing against me. Suppose it has been vested by on the state government by operation of a law of 1948 Act. There were two acts under 1948, Land Acquisition, Act 1 and Act 2. In Act 1, Lordship will remember that Act 1 is a long-drawn process where I have to acquire the land. If the compensation, I can take the land. And they have a right to challenge this compensation before the district. Act 2 of it is immediately by notification under virtue of Section 4, I can enter into the land and I can do the exploitation. Now, Lordship, that second Act 2 was challenged in several courts, including the Calcutta High Court. In the division bench, it was decided that no, Act 2 is bad in law. It has to come to an end. It was a special thing that. Then, Lordship, that particular issue is even in another correlated matter is pending before Supreme Court of India, I am arguing in that matter as well. Now, Lordship, what I am saying is, forget about all those parts. Now, coming back to here. Now, Lordship, since state government even have acquired that in 1948 by operation of law of 1973, because second one is a central statute and a latter statute. So, by central statute and latter statute, it will also come to me. Because now, there are two types of mineral, major mineral, minor mineral. Minor mineral is the state subject and the major mineral is the central subject. So in the central subject, because now in the union list, it comes under my exclusive domain, central. So if it comes to my exclusive domain, Lordship, even if I put it like this, that someone after acquisition of the land by the state government is in agreement with the state government that he will conduct this, or a state government PSU is conducting this, Lordship, they cannot. Even for a state government PSU, he has to take a coal block allocation to me, which is a very famous case of coal block allocation. So now all coal block, we say seam. Blocks means seam. So we are only in possession and title of that coal. Now, many companies have their own collieries, like Steel Authority, because of their manufacture, or a very big company can have. So they have to take permission from me. So we have a ministry for that. We have a secured every detail for that. So Lordship, if today, if he is running a case that it was a colliery's property, which I fought with the colliery and got back, so how Mr. Banerjee's client can take? If that is the argument, then Lordship, and a pure question of law, after 1973 Act, since he admitting the colliery action there, so it is no more with him. So this is my pure question of law, because disputed question I am not going into. Now, Lordship, what the case he is running? Let me see the case of the writ petition. Lordship, the writ petition is coming. Kindly come to paragraph 18, and Lordship, kindly indicate whether Lordship's brief has got P8 or not. My brief do not have the P8. Lordship, in the writ petition, Lordship has got P8. Which is and then Lordship, if Lordship is not finding P8, then kindly turn back to paragraph 18.
P8 is there, yes.
Lordship is getting P8.
P8. Is this a
Annexure
Eastern
P8,
Court?
Lordship is looking into annexure P8.
One notice is there? This is
Yes, yes.
Yes. It seems so. Now kindly see the averment in para 18. It's unheard of that a central government's company chairman cum managing director is writing a letter for requisition acquisition.
oh,
And then they say, it appears that 3 fake name of person, notice, phone number are putting their rubber stamp, reason best known to them. So it's an allegation on my head of my institution that we have tried to fake it. But no one has got a personal vested interest in the matter. Collier is land, it will come or it will not. So Lordship, that is his averment, and that gives his cause of action of the suit. This is his cause of action of this present writ, or even the suit earlier. His apprehension and his standing before the court, presuming that he is the owner, something is taken away from him without due process of law. So he wanted the judicial intervention in that. That's the plain and simple case. So he runs his apprehension from this particular document.
yes.
That this is how we have done the fraud.
Yes.
Now, Lordship, kindly turn to now, Lordship, kindly turn to page 99.
Of the opposition. And then of the opposition.
No, Amar reply.
Opposition.
File করেছি না? Bidding opposition here. Lordship, kindly come to my page 99.
Before that, you just come to the Coal Mines Act.
Yes, Lordship.
You just indicate the provision
Yes,
by which it is stated that on the date of promulgation of this act,
Lordship.
if a particular land is being used as a colliery, not used, excavations have been made of colliery, that will automatically be vested with the government. Which is that exact provision?
Lordship,
You
that
have
is-
indicated the definition of mine.
Yes, Lordship. Lordship, I read it, Lordship.
Code works.
Kindly come to section 3, Lordship.
3. Yes, you have not noted.
Lordship wanted to know how become right title interest come on me.
Yes.
Yes. Then the section 3.
Because if it is a colliery, as per you, nothing remains with the owner. It is not a case of any.
His own admission.
Yes.
So my lord,
Wait, sir. Let me understand. Yes.
So, Lordship, on this appointed day, right title interest of the owner
Yes,
in
yes, yes.
relation to coal mine Pacific in the schedule stand transferred to and vested to the central government free from all income.
Yes, yes. Thank you.
So I become the owner.
Yes.
Now, Lordship, kindly come to, if Lordship has taken that 3, then why the ownership of his is important then? His ownership is important. Why? My title will not be affected. Vesting will not be affected. Acquisition will not be affected. For the purpose of getting his right under section 8, page 58.
Page
58.
58. 6 and 8. The owner of every coal mine.
So if he can really show that he was in possession, what he's saying, that I was in possession, land was in my possession. So that might affect his section 8 right.
Yes.
So the section 3 he cannot touch and hear unless this act is declared ultra vires. So for section 8 he cannot stand before your lordship. The forum is different. So lordship, kindly see, whatever he trying to show that the ownership is not there with them, I recovered this, assuming everything true. So it can give him a best right for 8. So this could be his best case. Now, Lordship, I will place my case. Now, Lordship, kindly turn to page 99. May I read this, Lordship? In the year 1988, this is to inform you that an application under 226 of Constitution of India challenged the purported activity of non-considering the petitioner's application for correction of record in respect of land being Mauja number Charanpur, such and such, such and such, such and such. His Lordship Honorable Justice N.K. Mittal, upon notice to you when after hearing the same, has been pleased to dispose the writ and pass the order directing the petitioner to file an application for correction of the records of group such and such, from such and such, 4 weeks from such and such, give an opportunity to be. So, Lordship, in 1999, he got an order from the court of law to consider his name. Similarly, Lordship, that has not been considered. So, he made an application, not been considered. Then since after 1997, the Land Reform Tribunal, LRTT, has come into force, he has again gone back to that. Then LRTT has given again an order to consider his case. Now, while considering his case, Lordship, kindly see, I will take your Lordship to the consideration of his case. Lordship, kindly turn to page 117.
Mm, 117 is probably the civil suit.
Yes. So the title suit is 294. I will take your Lordship to the BLR of order sheet, which my learned senior friend has already done. So I'm skipping that portion. I'm taking Lordship to the suit, that at best right which accrued to him. Lordship, 1964 suit. The plaintiff during his minority took such settlement of land such and such, such and such. Now, Lordship, kindly see the prayer. Prayer is at page 119.
Yes. Record of rights is a final published. Correct.
Lordship has got the prayer A.
Yes.
Now, Lordship, the prayer is revisional settlement RS. Lordship, the land record goes like this. Initially, it was CS, then it was RS, and today it is LR. So, when there was a revisional chart, today is LR. So, from RS to LR, there was a verification. So, till today, he could not get it. Because what I'm trying to show is, first is the vesting. Second is the 1999 is the court order. Then is the suit. Suit prayer is declaring RS as a void. So he says today this suit is compromised, decreed in his favor. But Lordship, if at all it is decreed, unless it is collusive, even then RS has gone. Recording of RS has gone. Now the LR has come. I'm giving him full advantage of his pleading that yes, this has been compromised or not compromised, decreed in his favor. That can be the best case. So if it is decreed, the prayer A is decreed, then also the RS is not there. Today we are going by the LR. Now, Lordship, kindly turn to page 121.
Yes.
Now, Lordship will find this document is written statement by 2. Lordship will find who has affirmed this written statement is from page 124. C. M.C. Lennon, the officiating chief mining engineer and principal officer of Equitable Coal Company Limited. Lordship has got it from the verification.
Okay.
Because till 2002, there was a verified plaint and verified written statement. After that, we have gone to this. Now, Lordship, kindly see. Now, kindly come to para 8 of the written statement, Lordship. Then we will understand the flow of that.
Yes.
Lordship will mind that this document is of 1965. Lordship will again get it at page 124, verification.
Yes, 1965.
Yes, Lordship. April 1965. Lordship, then paragraph 8 is the Messrs. Apkar Colliery went into voluntary liquidation by a registered deed of sale dated such and such. The liquidator of Apkar Colliery Limited sold unto the answering defendant the suit plot along with the other properties. The defendant, since his purchase, has been possession of an khas making bricks and for other colliery purpose.
Yes.
So then in 1965 also, there was a colliery action. Now, Lordship, kindly turn to page 126.
Yes.
The plaintiff begged to state that the defendant number 2 have filed the written statement in the suit stated therein. They have purchased the right title of this and the amount someone such and has not been awarded such and such, and such name of defendant should be deleted. So then ultimately it comes to one colliery only, that is from Apkar to
Equitable.
Now, Lordship, kindly turn to the order sheets. I will skip few orders, Lordship, which is not relevant. Then, Lordship, kindly come to page 137.
Yes.
Lordship will find that Apkar name colliery was deleted.
Yes.
And then Equitable Coal Company is there. The schedule is the part and parcel of the land, next page, situated at Charanpur, Colliery, CS plot number such and such, such and such, such and such, pertaining to this. Lordship has got.
Yes.
Kindly see and visualize how fraudulent activity has been done. In a compromise petition, they are saying the CS record is compromised, and in the plain, he is saying RS record need to be changed. Lordship, I have shown that revisional record, RS record, in the plain, Lordship. So plaint is first. When if someone is filing a plaint, then RS record. Then he is compromising on CS record. Because CS record was the Jamindar records. Pre-independence. Britishers record. So kindly see the compromise entered by them from the document.
At the time of RS records, the Colliery has been recorded. That's why he filed a plaint for correction of the record of
Right.
Now, at the time of settlement, he gives CS records that goes back to the
Yes. So that the court could not get hold of him. And of course, a colliery is entering into action with him from a stating that the CS number this.
Yes.
Now, Lordship, kindly see, I am trying to visualize on that period. A man got a degree, he never executed the degree. If the degree is not executed within 12 years of passing the degree is dead. Unexecutable degree. He chose not to execute. Lordship, there is a reason why he chose not to execute. To execute the decree, a mandatory injunction or a declaratory injunction has to be there on the state government, because the correction has to be done by the state government. And he may choose not to party the state. He asks for the correctional record without making state government a party. Then in RS, settlement in CS, and no filing of execution. It might be a bona fide mistake of the lawyer. Then he would have filed it. The court would have said, how can I execute it against the state government?
Yes.
If it is a bona fide mistake, it would have taken its own flow. But they choose not to go by the flow. They picked a few documents from few points and always ventilate before your lordship that, see, something has been taken out from me without giving. That's the case they are trying to place before the different courts. So, Dick, I will put a question to myself, what is the effect of a degree? Because it's neither a declaratory nor a mandatory. It's a compromise degree under 23(1). Then lordship under 23, if it is a compromise degree passed under 23, non-executed between the parties, then lordship, what is the right he accrue on that? So the decree do not stands, as if decree do not stands. In any case, decree do not stand because of 1973 Act. But still, if I say that Act is even not there, then also the decree do not favor him, lordship. Decree has to put into execution. Every degree is tested and should pass through Order 21, including Rule 100 and 101. If someone is not a party, he can come and join as a party. Kindly see his perseverance in the matter. If I see the CPC and his action, then lordship, he choose not to put it in 21, because if he choose to put it into 21, the state government can come and play for the nullity of the decree under Rule 100 and 100. So very planned way, in my reading of the brief, very planned way he has flown this. Now, Lordship, I will come back. At page 105.
Yes.
Same man. Now, what his stand was in 1994. Let's see. I have seen his activity from 1990s. 1994, 95. 4 is the plaint, 5 is the WS. Then again, within 7 months of the WS, it goes to settlement, choose not to execute. Then after 65 to 77, in between 73 is my this. Then what his stance in 1994? Because 94, this gentleman is aware of everything. He knows his own degree, own right, law of the land, and then he is coming to the court of law. 1994, 2011, November 2004, page 105.
Yes.
November 2004. The BLR of Arbany, such and such, is directed to treat the application representation before him and dispose of the same with a law by the reasons order after affording just, fair, equitable, such and such, all the intended subject land within the period of 6 months. Application is directed to serve a legible copy of the judgment and decree of 1964. Lordship, kindly see. Before the BLRO and this, it is made clear that if the land was vested in the state under such and such and disposed of the application in view of the provision of section 46 of such and such, it exited prior to the substitution of section this. In terms of the application, such and such is disposed. So, Lordship, then even in 2004, he was aware of that the vesting has been done.
Yes.
Now, Lordship, kindly turn to the recording. In 2006 to 2009, page 106.
Yes.
Received an order of Honorable Tribunal, such and such. Tribunal ordered consider this application as a representation, dispose on scrutiny. Officer record that the plot mentioned in this order, such and such chapter, Mohanpur, such and such colliery, recorded under such and such, which were interminable Khatian, and those stands vested under section 4 of West Bengal, this, the Khana and such opened in favor of Upper colliery on the rather than Rayat Vagana and Suit plots. So this is how the matter is opening. They're saying that this is colliery's land, section 4 exercised, came back to the state government, and then subsequently state government to the central government, and then including the suit land. Because the court said that the suit degree has to be considered. Though he has not filed execution, maybe it's a bona fide mistake on his part, then Lordship Court has given an equitable look at his all grievances. All right,
Yes.
you have got a decree, I will consider your degree for recording him. So this is how in 2006 the matter opened. Now, Lordship, I will skip few. Lordship, kindly turn to page 108. So, Lordship, he has left the suit court. Then he knocked the court of the Honorable High Court. High Court said, look into. Then he goes back to LRTT. Then again, he chose not to file any contempt. Previously, no.
No, after this suit, he approached the LRTT.
Suit. then High Court, then
No, High
first
Court is of 1998.
Gotcha.
High Court is of 1998 of
Yes.
Justice N.K.
Then
Mitra.
2004 is the LRTT.
Yes.
Then in terms of the LRTT order, which now I am placing before your lordship, then he has again gone to LRTT. I will take your lordship. Now, lordship, kindly
2003,
see.
yes. This is after the High Court's order, he approaches LRTT.
High Court had order, he made a representation to me, not done. He has again gone to LRTT. By that time, LRTT started functioning.
Yes.
So then LRTT remanded it back to the inquiry officer. Then this is the inquiry officer where I am standing. The CR is put up today. I am reading the December 2009 order. No response even received by the officer from ECL concerned. It amended that the land was not acquired, nationalized. It annexed that the land was not acquired by the ECL, the provision of LA Act, nor it has been nationalized on perusal of such and such. It appears that the disputed plot has been recorded in the name of Abdar Kolihari, Khatiyan number such. It is evident that the matter relates to the provision chapter 4 of such and such 29. The provision all lease of the mines and the minerals in the notified area granted by intermediary as subsisting immediately before the vesting shall with effect from date be deemed to have been granted by the state government in the holder of this subsisting lease on the same terms and condition as the subsisting. So the initial order was, lordship, the law he is trying to establish that even if West Bengal Land Acquisition Act has come, then by operation of 4, the intermediary goes, means he was the intermediary because he became the owner of the land, then given to a collier. So by operation of West Bengal land, he will remove, and the state government will become the owner as if the colliery obtained the lease from the state government and royalty has to be paid to the state government. This was a scenario prior to 1973. So court has recorded that, well, that has come because prior to coming of this operation, it has come to state government. So what I wanted to mean by saying this, that his locus standi goes away. Then the Opkor colliery remains and state government remains. And after 73, Opkor colliery goes, central government comes. So today central government pays royalty, mineral royalty to the state government. So law is like this. First, the intermediary was gone by the state law, and by the central law, the colliery goes and the central government takes care of the. So today is now between two organ body, Article 12. One body is the state government, one body is the central government. Central government pays loyalty for the every colliery to the state government. That's the present status. So how it has arrived is, this is the story. State government took the intermediary in their hand and the central government took the colliery in their hand. Now, lordship, kindly see, hence it is clear that the state government become the lessor of the disputed land as the said colliery was subsisting before the date of vesting as well as after the date of vesting. So the question of the resumption of such colliery land by other than the state government is contrary to the provision of section 29 of West Bengal Estate Acquisition.
Yes.
Original copy of such resumption of Oxwell Company was produced during the hearing. But the date of the said letter was found, I could not read, in the eye of the law, and it was made totally beyond the jurisdiction of against the provision of chapter 4 of the West Bengal. Hence the claim for recording the land compromising mineral and covered by chapter 4 of West Bengal Acquisition Act 1953 of the cannot be maintainable in IF. In case number such and such, state government was not made a party and the state government could not defend the said suit. Hence, in my opinion, the disputed plot sought to resume by the state government as such and such, the order passed by the learned Municipal is not binding upon the state government. Hence, the application is disposed. So, he has taken a clear chance that ICL has not come. So, what is happened on this day, I don't know. But he cannot come because state government has substituted him. So, that order is recorded. Now, lordship, kindly turn to page 111. 2019 order.
119.
111. 1.
Yes.
The learned counsel appearing for the state government, the appears praised withdrawal of the instant as the same is suffering from the inherent defect. There is a liberty and such and such, block such and such, in representation such and such. The applicant is directed to sub the copy along with the annexure and the copy of order such and such according with law, with preferably Bardhaman is directed to dispose the representation file such and such from filing of representation such and such. So Lordship, in 2019, he again made a representation which was a closed chapter because that order has not been challenged. So what he does is he slips over for some time, then he makes a representation, he goes to the court, and then he says, my representation only need to be considered. Moment the representation is considered, he gets a fresh call. So Lordship, if I look into his action, 1964 was first attempt, 1998 was the second attempt, 2004 was the third attempt, 2006 to 2009 was the fifth attempt, and today this is the sixth attempt of this gentleman to reopen. And he got successful in this because most of the time when the lawyer for the defendant usually do not oppose when the consideration order is passed. So Lordship, he took all the advantage of unmindfulness of the lawyers and then he got this order as well. Now Lordship, kindly turn to the next page, page 112. In 2019, Lordship. Lordship will see this is the order of February 2019 and then next order is March 2009. Where it appears the office undersigned dated a representation of Shivdaj Mondal and other pursuant to OA number such and such the matter. Whereas the scrutiny record that plot number such and such were recorded earlier in RS number such and such were intermediary Khaitan and vested on the state by the combined operation of 4 and 5 of West Bengal estate acquisition opened in favor of Aptar Colliery such and such recorded. All plots were recorded in favor of. Now Lordship, then
Yes.
whereas it appears that on such and such, so hence the undersigned BLLO takes up the record and then Lordship, he takes up the entire record and Lordship, the final order is of June 2019, Lordship. It starts from page 140. Sorry, it will be May 2018.
18.
Then Lordship, the such and such appeared the file and such Hajina and all gone through the written submission. Then Lordship, in the from the bottom third paragraph. As it is a matter of mines and minerals, the matter related to the provision of chapter 4 of WBEA, such and such, the West Bengal envisaged the provision that all lease terminators is notified, granted such and such, with
This
effect
is a
from
similar
such
finding of the previous order.
they did not take the plea of res judicata or something, but they, of course, the earlier order not set aside by a court of law, he abide by that. And which is also a record. The record did not change. Then Lordship, kindly see, then same thing he reproduced in the next page, Lordship, 106. 16.
Yes.
Now kindly see the very another statement he has added. He actually reopened. He did not copy the order of the earlier and then put it here. He said, at least you show me some document in your favor. So that he has also a compensation. So he said that the property is yours. Apart from this compromise, you produce any deed which was there in your favor. Lordship, he could not produce that deed. May I place that portion of the order? Next page, last but one line. Last but one paragraph. Furthermore, the undersigned has gone through the order of TS, wherein the state government has not been made a party. And therefore, the state government could not defend. The order of Munsef is not binding on the state as it reports or resume the state government. The applicant further could not produce any valid registered document with the land scheduled in support of their claim, hence the applications. So what he said is, if you have compromised, by compromise you cannot get a title. You have to have an independent title. I file a suit against my learned senior friend saying that monument is mine. Then he compromised with me. It's all right. It's yours, Mr. Ban. That will not. Compromise means he relinquish his right. But I have to establish my right that I purchased the monument on such and such date from this document. So here, next, in the second round of BLRO litigation, they have gone a step ahead. All right, you compromise because you are taking so much of strength from your decree. So I will give you effect to your decree, but show me your title then, which he could not. So that's the order of the BLR, which passes in 2018 or 19. Now, Lordship, now, after passing of 2019, then you kindly, Lordship, kindly come to 147. Moment that order was passed,
Yes.
this is this writ petition which is for now dismissed for default.
Yes.
By this writ petition, now he left the state government and recording of name off. Now he started catching off Eastern Coalfield Limited, who are in possession and conducting the mine. Now he comes to the court in 2019 and then in 2023. Now he says, why Mr. Banerjee's client is doing mining? I have a degree in my favor. He tried the decree with the state government. State government, though was not a party, they could protect themselves. Now they leave the state government. Now he holds up my PSU because he knows record of right is not with me. I cannot defend myself. If I see the decree, I will be nervous. So now he holds of me and say, why you are doing the mine? This is my land. I have a compromised degree. So that's the new era he started from 2019. Now kindly see in 2019, he has made the government, state government as a party, and now his action is against me. Kindly see the prayer. Kindly see the prayer of at page 160.
Yes.
Very similar prayer of the 23 writ.
Yes.
Again, he has taken a point that why order should not to stop the negative injunction. I don't know whether it can be passed or not, but Court of Equity can always. The respondent to stop the process of vesting.
Which has already been done way back.
He is aware of, he contested, he could not produce it. He knows about the state government vesting. His right vested, the intermediary right has vested by the estate acquisition. He is aware of that. Final order passed. He chose not to challenge that final order of 2019 order in LRTT. He chose not to.
Yes. The subsequent order passed after the representation was not been challenged before the tribunal?
No.
No, that is not challenged. Yes.
So that is not challenged. Now from 2018 and 19, he has come back to High Court. And now he has made me a party everywhere. Challenging that you are doing excavation work, so you are responsible. And then he couched his prayer, stop vesting. Kindly see the words. So many times it cannot be a coincidence. He forgot file a RS, then CS, Then he could not produce the document. These are all coincidence with him. Then he forgot to challenge the last order. Then here he is saying stop vesting. So he is not aware it has been vested. So today he comes before your lordship with a figure that I don't know anything of the past. Someone is doing a mining in my plot. Please stop him. So that's the case he has made up.
Yes.
Now kindly come to 166.
Yes.
Now, Lordship, kindly come to 166. He did not stop there. In 2023, he filed this matter, which is dismissed for default. 23, he filed another writ. And he chose to file another suit also against me.
Yes.
The case of the plaintiff in a nutshell that the suit property originally belonged to the great grandfather of the plaintiff, namely Gopinath Mondol, who executed a lease deed on in favor of Apkar Koliyari. Subsequent, the lease was expired on this, and then compromise such and such, BLRO such and such, published such and such, Apkar Koliyari such and such. Then Lordship, decision, document submitted. Then Lordship will find the decision on the order at page 168. The present application under Order 39, Rule 1 and 2 of CPC, ad interim on your BS, same is allowed ex parte at this stage in this. The defendant and his main agent restrained from distributing the peaceful possession of the over the suit property, such and such, further restrain evicting the plaintiff by doing any act, issue notice such and such. Lordship has got it. Then Lordship kindly turn to page 170.
This is a defendant is only ECL here in this suit.
Now he changed the stand, Lordship. Now he left the state government. I have a copy of the plain, Lordship. Now because now he is not going by Section 80 notice. Now state government Section 80 notice, all record will come, GP will be there. So Lordship, now then second.
Yes, 170.
Lordship, 170. Then Lordship. Sorry, I will come back at 2 p.m. Lordship.
No, 170 I am. In 170.
Now kindly turn to page 171.
That was the interim injunction.
Refused.
No, earlier one.
No, this is another suit, Lordship.
Oh, this is another suit.
Yes. TS 713.
Is there any other suit?
Succeed to get a ad interim.
Before the similar court he files because the jurisdiction is same. Is it before the sub-judge or?
Lordship, this is before Civil Judge Junior Division 3rd Court.
Earlier one was
And
also.
earlier one was Civil Judge Junior Division 2nd. I don't know how because
How this-
Thana and the scheduled land remains same.
Okay. We stop here.
Lordship.
You prepare a list of dates of the happenings. Just a short.
I will.
Prepare that. That will be sufficient. You have almost concluded, or how much
I
time?
will show another 2 frauds, Lordship, then I will stop.
Okay. এটাকে কন্টিনিউইং এতে থাকবে একটু শর্ট ডেটে করো কিন্তু কনক্লুড করে দেবো মিস্টার ব্যানার্জি বন্দ্যোপাধ্যায় how long you will take because he has almost covered Because now the ball is in his court, so he is suffering.
The land vested to the state.
Okay.
State is the lesser, career is the lesser. And it is recorded in the name of the career.
দেখো আমরা উইন্টার ভ্যাকেশনের আগে এটাকে
It's a clear material fact, suppression of material fact.
3, 6 আর 16
Yeah, I will
3,
submit
6
something.
আর 16 ডিসেম্বর মাসে এই তিনটে
I will submit something.
let him complete, then I will come back to you for having your replies. Let him complete what he has indicated. You just take note of it and make your reply. 13th, Mr. Banerjee. প্রীতম ওটা ফাঁকাই যেন থাকে এটা যাতে নিতে পারি 13th. Heard Mr. So and so, learned advocate for the petitioner, who concludes his argument. Mr. Shiv Shankar Banerjee, learned advocate, appearing for respondent Eastern Coalfields Limited, places his points of argument. Due to paucity of time, the hearing could not be concluded. List this matter on 13th December 2023. At the top. Top is beta? Top. 13th কি বার পড়েছে এটা? শুক্রবার। Top.
Friday, my lord. Friday.
After this, the original side matters will they will. 13 is the next item. তো মানডেতে আসতে পারবে এটা? তারপরে তো এটা থাকবে। After দুটো টপের পরে দেখ Monday we'll see. There are 2 top matters. After that, your matter. Okay, thank you.
Acha.
Any mentioning?
Your Lordship passed an order on 1st October. There is a calculation mistake. Chandra and Chandra. For that, Lord, bank has disallowed Lord inventory. In spite of Lordship's order. I have and order as well as Lord
It is
Aadhaar
submitted.
card. The second page Lord of this order.
Paresh Nath.
Forest Nath Chandra, CHANDR. Instead of Chandra, it has written CHUNDER. But for that, Lord, bank refused to give inspection of locker. Lord, yes,
Oh, her son.
yes. Lord, yesterday, Lord,
Paresh Nath.
Chandra, CHANDR.
Where is the application?
Here. Application name is not there. Lord.
Name is there. Name is there. মাস্টার সামান্সটা কোথায় আছে?
আছে
না না এখানে মাস্টার সামান্সটা আছে?
আছে
প্রেয়ার দেখুন সেদের নাম দেওয়া আছে। ফার্স্ট প্রেয়ার দেখুন ওইখানে দেখুন ফার্স্ট প্রেয়ারটা কোথায় আছে? Who will accompany?
accompany
নাম এরই মাস্টার সামান্স। অ্যাপ্লিকেশনটা কোনটা? কোথাও তো আছে, মিস্টেক হবে না। Where is the application?
this is also there.
You have not stated the name?
That will be there, that Lord, I have said Lord Forest Nath. It's younger.
Okay. এটা দিয়ে দিন to mention. Bring a document of it. What is the spelling of the name?
Forest Nath Chandra. I have handed over Aadhaar card.
দেখি but the other legal years are having the title as CHUNDER.
Yeah, written CHNDR. That's not CHUN, he is written CHNDR. Other card is also CHNDR. Predecessor CHUNDR. CR.
কোথায় বাবু আধার কার্ডটা কোথায়?
Xerox copy অর্ডারের সঙ্গে দিয়েছি।
কালকে মেনশন ইন্ডিয়ানই কালকে সাপ্লিমেন্টারি লিস্ট করে দিন। This matter is listed in the supplementary list. Mr. So-and-so learned advocate appearing for the petitioner submits that the spelling of the name of the son of the petitioner would be Paresh Nath, Pareshta alada, Nathta alada, Paresh, Paresh, Nathta Nath, Nath, Chandra, Chandra, instead of Paresh Nath Chandor, Chunder, as noted in page 2 of the order. Passed in dated to Nini order 1st October 2020. He seeks for modification to that extent. The order dated 1st October 2024 is modified to the extent that the name of the son of the petitioner be read as Paresh Nath Chandru instead of Paresh Nath Chandur in page 2 of the said order. The other portions of the order shall remain unaltered.
Kindly act, and bank will act on a server copy of the order. He is asking certified copy. It will take some time.
All the parties will act on the server.
Thank you.
Original side, daily list item number 1.
My lord, I appear for the plaintiff, my lord, in this matter. This is appearing at the instance of the interveners for extension of the interim order that was passed in IAGA 18, which was an application taken out by the interveners.
My lord, I am appearing on behalf of the interveners. We have GA number 17 and 18. The original order passed was of 18 January 2023, which was subsequently modified, my lord, on the 18th of April 2024. We only pray for an extension of the next returnable date. I'm being led by Mr. Shurojit Nath Mitra in this matter.
My lord's last order of 11th of September records the entire facts. If your lordship kindly sees that, my lord, that would possibly help the bench.
Prosperity.
Oh. This matter is appearing under the heading to be mentioned. Mr. So-and-so learned advocate appearing for this, appearing for the interveners, submits for extension of the interim order passed on 18 January 2023. and modified by the Honorable Division Bench on 18th April 2024. The interim order passed on 18 January 2023 in IGA 18 of 2023 and modified by the Honorable Division Bench on 18th April 2024 and lastly extended on 11 September 2024 is extended. অঞ্জন বাবু কবে আসতে পারে এটা? আমরা জানুয়ারিতে লাস্ট উইক অফ জানুয়ারি করে দিই না এক্সটেনশনটা লাস্ট উইক দিচ্ছি is extended till the last week of January 2025. List this matter in the monthly list of January 2025.
Grateful, man.
Grateful, my lord.
Directly under the heading hearing production. Item number 2.
I'm led by Mr. Kumar. I'm led by Mr. Moinang Bose. He's
Only?
out of session.
The microphone is on.
জোরে বলুন জোরে বলুন
I'm led by Mr. Moinang Bose. He is out of station now.
Where is your witness?
My lord, kindly.
This has begun.
My lord,
Witness action has started.
no, my lord. It's a first day.
Sort modified appropriate.
Kindly keep it on next Friday.
So and so. Learned advocate for the plaintiff seeks accommodation. Defendant is not represented.
My lord,
None appears on behalf of defendant number 1. What is his name? Witness? Witness
Kumar Roy.
Sukumar Roy is present. Witness Sukumar Roy is present again. The top of the other way. A line. Top of the other C6. None appears. Please, this matter. 3 weeks. After 3 weeks. 3 weeks for her.
Item number 3.
Lordship, I appear on behalf of the plaintiff, Lordship. Today's date fixed for examination in chief on behalf of the plaintiff, Chandra Prakash Jhunjhunwala. But he is a senior citizen and he is under bed rest because of doctor's advice, Lordship. Can the matter be listed in January monthly list?
January, he will be okay.
Yes.
Huh?
Yeah. I think he will be fine by January. A very old aged person, Lordship.
Yes, my lord, I'm for the defendant.
After so long, you have deposited the penalty.
Yes.
Now your witness is not ready. How long you will carry on this?
But
Lordship.
registration has not.
Several orders were passed. Thereafter, you deposited the penalty and the stamp duty.
Lordship, he is very sick. He is very ill.
Correct. On 18th November, you submitted that for adjournment. On your player, this matter is listed today.
Lordship, he is
So you have to ascertain now what is the use of listing this matter. Let the matter go out of list now.
No, Lordship. No.
Let him recover. Thereafter, liberty is given to you to mention. Carrying on one after the other, you are seeking adjournment. Next January also, he will not be okay. He will seek adjournment. If he is well, ask him to come. Otherwise, the next day I will make it out of list. Now, on the prayer of learned advocate for the plaintiff. Agar note করুন Miss So and so learned advocate. What is your name?
Ishita Kundu.
Miss Ishita Kundu, learned advocate for the plaintiff, submits that the witness What is his name?
Chandra Prakash Jhunjhunwala.
Chandra Prakash Jhunjhunwala could not come to court for his deposition due to illness. She seeks for listing the matter in the month of January 2025. In view কবে যাবে? List this matter in the monthly list of January 2025. Okay.
Grateful.
Monthly is January. New chamber application item number 4.
This has come at my instance, man. This is that matter where in terms of settlement, my lord, there was a error of 2.085 and 080. We have filed a application. We have filed an application for clarification of the same. Kindly, if my lord takes the master summons. Wait for the same. And that allowed my lord that page 11 point I place of 2.0.85. It should be 2.0.85 in place of 2.080, my lord.
Where is the order of this?
Terms of settlement is that, my lord.
Where is the order of this court?
On page 29, my lord.
Page 29, my lord.
Oh,
Page 20.
what was stated in the terms of settlement? It was 2.085.
Page 24. My lord can come to page 24, page 11 of the
Oh.
terms of settlement.
So 2.080 is not correct.
Not correct. The 2.085 should be the correct figure.
It's a typographical error.
Typography.
Tabular is correct. Tabular statement is correct. This is an application. Yes,
Number 10 to 12, my lord. No.
you have no objection. This is an application seeking for clarification of order dated 7th August 2024. Mr. Adil Rashid, learned advocate, appearing for the plaintiff, submits that the in the terms of settlement filed before this court, a typographical error has crept into point number P I at page 11 in 1, 2, 3 in the fourth line. Mentioning the ratio of the wife and daughter of the of late Ratan Lal Sarawagi as 2.085 0.080% each, which should be 2.085 in terms of the tabular statement provided thereafter. The order dated 7th August 2024 is clarified to the extent that the share of the wife and daughter of late Ratan Kumar Sarawagi would be 2.085% each, as per the tabular statement appearing at point number 3I at page 11, instead of 2.080%. As mentioned in point number 3I at page 11 in 2 in the fourth line. Let there be order in terms of prayer A to B, A, B and D. What was the time? Was there any time to draw up this decree?
The timing was within a period of 6 weeks, I think so. That has 8:30, my lord.
Okay.
My lord, within a period of 6 weeks, my lord, on the in GA 18, my lord, when the lordship
D.
But these corrections be incorporated in the original terms of settlement because this will form the part of the preliminary decree.
That is in the prayer D.
But that is the correction to be made.
Huh.
But that correction has to be incorporated in the terms of settlement so that it
The corrections will be incorporated as a point D in the terms of settlement. The terms of settlement by the previous order has also been made part of the preliminary decree.
My lord, but and they kept before and kept on record before this honorable court. But that after correction, it will form the part of the decree.
The corrected terms of settlement will form part of the preliminary decree. The time to draw up the decree is extended. The department is directed to draw up the decree within a period of 6 weeks from the date of this order.
Grateful, ma'am.
My lord, in one place, my lord has said Ratan Lal Sarogi. It should be Ratan Kumar Sarogi. The name is Ratan.
Ratan Kumar ko Ratan Lal bolechi? Ratan Kumar ko. Labar asked me to be mentioned. Ratan Kumar. That is the application being GA 19 of 2024 stands disposed of.
I don't know if I
Lordship, I'm appearing on behalf of the petitioner.
Lordship, I'm for the official evidence.
I'm being led by Mr. Anubhav Sinha in this matter. Lordship, due to the demise of his father, he is not available right now in the court. I request your Lordship to hear this matter during the second week of December.
On the prayer of learned advocate What is this application? This is
There has been some amendments, Your Lordship, regarding the cost title because defendant number 3 has taken up this application. The defendant number 3 has been added as a party. Actually, this application is not at all maintainable also because the defendant number 3 by date of this application seeking amendment in the restoration application which was filed in the year 2017. So there was an order in the month of May 2024.
so let them file their opposition. Huh? In the meantime, you also, if you intend to file, let them file their opposition. Excepting you, is there any other defendants?
Lordship, I'm the plaintiff actually because the company has gone into
Any other
liquidation.
opposite party? You are the plaintiff.
The plaintiff. Aluminium Cables has gone into liquidation, so therefore I'm appearing on behalf of the official liquidator plaintiff.
And the applicant is?
Applicant is the defendant number 3, Ashok Jain. It's the added party.
Okay.
The main suit is primarily lies against the West Bengal state electricity distribution and Punjab National Bank.
Where is the file the affidavit of service? It is a new question. Oh. Affidavit of service filed on behalf of the petitioner is taken on record. Learned advocate for the plaintiff. Opposite party number. Respondent opposite party.
Lordship, in fact, in the cost title also, it should have been incorporated as in liquidation. That has not been done. The cost title is still defective, Your Lordship.
Seeks to file affidavit in opposition to the application. If such affidavit in opposition be filed by the plaintiff within 2 weeks, reply the to opinion 1 week, release this matter after 3 weeks.
Lordship, plaintiff, official liquidator, Your Lordship.
Official plaintiff and official liquidator.
Lordship. Because aluminium cables is no more in existence. Right.
Number 6. Well, my application, recalls that matter, wherein we had taken out an application praying for mean profits, and there was no alternative prayer in respect of inquiry into the mean profits. So, we have taken out this application in order to amend that particular application, seeking for to incorporation of the prayer, regarding inquiry into the mean profit. That is the sum and
Shall I
substance.
oppose this application? Shall I oppose this application? My instruction is to file an opposition to this application. Lordship, will kindly grant me 1 week or 2 weeks time.
This is a simple application. I do not know it's an because prayer, whatever is there is there. My learned friend wants to fight it out, it can fight it out.
No, I have a right to file opposition because my case is my contention is that he's changing the nature and character of the original application. So Lordship will kindly grant me a short opportunity.
Profits, in that particular application.
Kindly grant me a short opportunity.
The only thing that I'm seeking for is an inquiry into the mean profits. It's an alternative prayer.
Yes, this according to me, this changes in nature and character. Lordship will kindly grant a short time to use an affidavit.
Auric Banerjee, this is an application for amendment of GH 18 of 2020. Mr. Auric Banerjee, learned advocate, appearing for defendants. You are
For the judgment data, Your Lordship. Judgment data. Judgment data plaintiff.
Plaintiff. Judgment
data.
You've got a counterclaim, so judgment data.
Yes.
Judgment data.
Yes, his counterclaim was allowed.
Seeks to file affidavit in opposition to the application. When is that application coming up? When is that application coming up?
That application was supposed to come up on
I believe 19th of December.
Probably, Your Lordship, 8 weeks from 11th November.
8
weeks from 11th.
Yes, it's 8
Oh,
weeks.
then January month.
3 weeks for it. 2 weeks, 1 week. Any reply event of 1 week? And leads the matter up.
Grateful.
Substitution. Affidavit in opposition to 2 weeks or reply 1 week and
Great.
উপরে চলে গেলে ভালো হবে।
7, 8, 9.
7, my lord, I appear for the
Complied.
special officer. Yes, lordship. May I just indicate
That matter of handing over possession, my lord. Special officer is filing the report, my lord, the compliance report. Articles have been handed over to the petitioner and the dues have been paid to the bank, and to that extent that certificate has also been issued by the bank. Now, my lord, the receiver has to be discharged, my lord.
My lord, may I make
And
a few submissions, lordship? Lordship, this is the order dated 19th of November. The direction was that the special officer will hand over all movable and assets to the petitioner on by 26th. On 26th itself, the special officer has handed over all the movables into the possession of the petitioner. My lord, my first humble prayer is let that be recorded in the order that the possession has been given over by the joint special officer to the petitioner. This is my first prayer, my lord. The second prayer, lordship, is that there was a direction to file a compliance report. May I file it in court, my lord?
my lord, a
And
copy
this
may be
also
served.
I am serving right now, my lord. And this also may be recorded, lordship. This is my second prayer that may be recorded. And third, lordship, the remuneration of the special
My lord,
officer.
that's there in my master's summons, and I'm pressing that prayer, my lord.
Initially, lordship,
In which master summons, which application?
My lord, GA10.
GA10.
GA10 take to the. So the other applications will be stands disposed of.
No, my lord, that is not disposed of. Your lordship can dispose
8,
of while
9,
disposing
8, 9
GA9.
and 10.
Yes, ma'am,
may be
that can be disposed of along with GA10. My lord, prayer C has been
Can you-
complied.
Prayer B,
B
prayer
has been
B has been
complied with.
complied with, and I have filed
My
the
lord, I am
report
pressing
today.
for the discharge of the special officers.
My lord, the
Upon
final
payment of
Payment of the dues, my
remuneration
lord.
may be decided by
Remuneration
you,
may be
my
paid.
lord, whatever my lord deems fit.
What was the remuneration?
My lord,
Initially, lordship,
initially he
I
has been paid 800
GMs in
GMs.
2013
200
by the order
2013.
in by the virtue of order passed by Honorable Justice I.P. Mukherjee.
Ma-
After that, nothing happened in this matter, but
There was
recently
no
this
exercise
year,
of the special officer in the
especially yes,
Now,
but this year
one of
it
these joint
has.
special officer, Mr. Rahul Sengupta, has
Yes, my
exercised
lord.
this
So
entire
he's gone to the
inventory
bank
and handing over the
twice.
articles
Some
to the
clerical
petitioner.
expenses and stenographer charges were their lordship.
My lord, another prayer, my lord, as the articles have been handed over to the petitioner on 26th November, the time may be extended to file the inventory and accounts. And that is also in prayer D of the master summons, my lord.
Extended by 6 months. Okay. A report of compliance furnished by the special officer Rahul Sengupta is taken on record. Mr. Dhillon Sengupta, learned advocate appearing for the applicant, submits that the inventory of the articles have been completed and the articles have been handed over to the applicant. Applicant is the administrator.
Administrator.
Administrator. He also informs the court that the dues and charges of the bank has also been paid. Miss, he seeks for extension of time period to file inventory and accounts. Accounts is also to file.
Yes, my lord. Account is
inventory
there,
and
my lord.
accounts.
The statutory time period is 6 months and 1 year. My lord, that be extended, my lord.
Ms. Devjani Sengupta, learned advocate representing the receiver, submits that.
My lord, special officer, if may be
Sorry,
recorded.
special officer.
I'm deeply obliged, my lord.
Submits that all the compliances and directions, all the compliances pursuant to direction of this court passed on 19th November
24.
2024 has been complied with.
Lordship will kindly record on 26th it has been handed over, my lord, subject to
The
correction.
articles, all the articles have been handed over on 26th of November
2024
2024.
to the petitioner, my lord.
She also indicates that after appointment of the special officer in the year 2013, no such remuneration has been paid. Para. Considering the submissions advanced on behalf of the applicant as well as the learned special officer, it is found that the articles have been handed over to the applicant administrator. The special officer is accordingly discharged.
Well, the special officers, because
Officers are accordingly discharged. Applicant is directed to pay a further remuneration of what was paid 800.
Initially, Lordship, 800 GM in
800.
2013 was paid.
2000 goes in. 2000 James,
Deeply obliged, my lord, deeply obliged.
which shall be paid by the applicant administrator. The time period for filing inventory and accounts by the administrator is extended for a period of
6 months and 1 year respectively.
6 months, but 1 year you have not paid.
Well, that is not paid in the master summons, but the statutory compliance is that inventory within 6 months and accounts within 1 year, my lord.
Period টা কি থাকে 6 months
Section
6 months
317.
and 1 year respectively. The applications being GA8, GA9 of 2024 and GA1024 stands disposed of.
My lord, 8, 9, 10. All the 3 applications can be disposed of, my lord.
All have been disposed.
Yes, grateful.
I'm deeply obliged, my lord, deeply obliged.
order করবে তিনটে একসাথে মিলিয়ে order 7, 8, 9 একসাথে For hearing item number 10 on this matter, I am for defendant number 2B to 2D. My lord will recall this application has.
But in before my learned senior proceeds, my lord, I am appearing for the defendant numbers 9 to 14. Mr. Subhashish Sengupta is appearing for the defendant numbers 9 to 14, my lord. His mother passed away yesterday, effectively yesterday, that is day before yesterday, late night. My lord, kindly, can it be kept after 2 weeks?
No opposition has been filed to this application, my lord, and innocuous prayer has been made.
Since no affidavit filed by even 9 to 14 listen. Oh. Advocate for plaintiff, accepting 4 and 5 informs. 4 and 5? Who is representing?
I am for the plaintiff except 4 and 5.
So you will not be filing any opposition.
On the last occasion, I stand corrected. My learned junior had appeared, and he said that the plaintiffs do not wish to file any. That is a wrong submission, Lordship. Lordship, I intend to file an opposition.
My lord, repeatedly, my lord, a contradictory stance have been taken in this matter, my lord.
On the last occasion, my lord, it was submitted that no opposition will be filed. My lord will find from the order sheets, my lord, repeated opportunities were being afforded to all the parties. My lord, this is a tactic, my lord, to drag the proceeding, my lord. My lord, innocuous prayer where I wanted to sell my shares are being admitted, my lord, and when opportunities are being granted to them by order dated 23rd September, my lord. If my lord will kindly see the order sheets, my lord, 23rd September, 2 weeks times were granted for filing opposition, which has ended. The matter then appeared on 12th of November.
Peremptory cause.
But I also served
Sir.
my lord, the special officer. In terms of last.
What is your name?
My name is Navneet Mishra.
Recorded. Who appeared on that date?
My learned junior had appeared, Rahul Singh.
Now, this is the difficulty when the names are being given.
Unconditional apologies, Lordship.
No, the difficulty is, suppose your junior has made a submission and your name is appearing in the order. In the order sheet, your name is recorded. Your junior gives the name. Now you come on the next day and say that I was not appearing. It becomes very.
Over and above, there was a judicial order on 23rd of September, granting them opportunity to file opposition.
Let them come up with the opposition. The directions are made peremptory. Whatever you do.
My lord, may kindly impose cost, my lord. My lord, they are taking court for granted, my lord.
Mr. Start Krishna. Mr. Navneet Mishra, learned advocate for the plaintiffs accepting plaintiff number 4 and 5, informs the court that on the previous date, within bracket, that is 12th November 2024, a wrong submission, incorrect submission was made by his learned junior advocate that his clients will not file any affidavit in opposition. He seeks unconditional apology and submits that the plaintiffs accepting plaintiff number 4 and 5 shall file their affidavit in opposition. What is your name, sir? Mr.
Abhrojit Roy Chaudhary, madam.
Abhrojit. Mr. Abhrojit Roy Chaudhary, you are representing
9 to 14.
Defendants, learned advocate for defendant numbers 9 to 14, submits that the conducting advocate, Mr. Subhasish Sengupta, is unable to attend court due to the demise of his mother. He seeks for short accommodation. You have filed your opposition?
Oh, my lord, we wish to file it.
You were not present on that day, on the last date. Please have these oppositions filed, at least the pleadings be completed, no? 2-3 days are going on, times have been given, but you are not responding. Then they will also have some time to file the replies.
Definitely before the next.
He seeks a short accommodation, no? Short accommodation to file affidavit in opposition. Let affidavit in oppositions be filed by plaintiffs accepting plaintiffs number 4 and 5 and defendant numbers 9 to 14 within a period of 2 weeks.
Let it be peremptory.
The reply thereto, if any, be filed within a week thereafter.
Great.
Release this matter after 3 weeks. The aforesaid direction is made peremptory.
Last occasion, my lord had directed me to intimate the learned receiver and the advocate commissioner.
Yes.
My lord, I have served, my lord.
Lordship,
as far
as this is concerned, it is my bounden duty to appraise the court. Lordship, the learned commissioner is traveling. He is not in Kolkata, Lord. So he could not be physically present today.
Learned advocate for you are for plaintiff.
I am for defendant number 2B to 2D, my lord.
Defendant number 2B to 2D
My lord.
/ applicant files copy of the letter of intimation to the learned receiver commissioner.
My lord.
Receiver commissioner, which is taken on record.
Great.
Mr. Misra, learned advocate for the plaintiffs accepting plaintiff number 4 and 5, informs the court that the receiver is out of station and for such reason he is unable to attend the court. Learned receiver is directed to remain present on the adjourned date. You intimate him. Mr. Misra, learned advocate for plaintiffs accepting plaintiff number 4 and 5, is directed to intimate the receiver of the next date of hearing.
Deeply obliged.
Much obliged.
Extremely good.
Lordship, I apologize once again.
Item number 11, I am for the petitioner.
Where is
I am for the remove executor.
oh, that matter? What happened? God?
Your Lordship's direction has served the copy along with your Lordship's
He
earlier
is
order
not there, no?
upon Mr.
Subhasis
Subhasis
Sengupta to nahi.
Administrator Pendilite.
I have served notice, but he is not there. I have been informed his mother has expired.
His mother expired.
When can he come?
That unfortunate reason he is not appearing today. We have nothing to say. Only, my lord, my prayer is let the matter be adjourned on the ground of the learned administrator for this matter as it is required. But only a direction be given to the removed executor on the next day to produce the bank accounts, the demat accounts and the bank accounts, and the bank statement.
Let the special officer and administrator.
I will have to I will submit. First of all, the accounts is still as it is on the date of removal. That is removed from the report filed by the IO itself. But there are some certain incorrect statements.
I am praying for
there are some
direction in respect of the bank statements and the demat statements.
There are certain disputes with regard to the documents. I have asked them to intimate the special officer. They have intimated. Now, in his presence, my contention was that whether it can be resolved.
I am also in the same boat.
You say that some documents have not been given. They said that we have given everything.
That's the
so you can sit down with the.
These are not the documents, my lord. Or there are certificates, physical and intimate.
If required, necessary direction will be given. Let him come. His mother has expired. After 2 weeks, I am placing the matter.
2 weeks.
Yeah,
No.
Subhasis
Sengupta.
Yes, I am sorry.
So, yes.
Yesterday was the.
So after 2 weeks, I am placing the matter. In the meantime, you work out the mechanism. If
I don't think my learned friend Millard is interested. I am always interested. There are many matters, Millard, I have been a part of, which have been settled. And I am, Millard, proud to say that I am considered to be a pro-settlement lawyer. And my learned friend, Millard, has to choose whether he wants to settle. Millard,
so your proactivity is much required in this case because it is pending since 13.
Yes. Now, what is, Millard, if your lordship sees this is such a, Millard, if I may use this term, Millard, meaningless litigation. Will is not under challenge. So, my lord, who's going to get how much is not under challenge. Extent of the estate is not under challenge. Just two people for the last 10 to 12 years fighting with each other as to who will administer, get some shares recorded in their own names, and thereafter they will, that's all. So we are fighting about who will write letters to these companies and get shares recorded. This is all. This has gone on for 12 years. My learned friend has been industrious enough to start a criminal proceeding also on this. This is the situation.
Okay, let him come.
The time of the submission is now over. Now he is, in one hand, he is
by order dated.
That his client is trying to solve the matter.
By order dated.
But raising
November 2024.
To me.
The learned administrator, Mr. Subhasis Sengupta, was directed to remain present. It is informed by the learned advocates that due to sudden demise of his mother, the learned administrator is unable to attend the court.
Delay, if any be called on, exception will be taken.
Mr. Jisnu Chaudhary, learned senior advocate appearing for a respondent, submits that
For the
is
removed executor, my lord.
for the he's not respondent.
No.
Removed executor.
Is there anything in the cost title? I asked my learned friend, he keeps using this expression, removed executor. Lord, I am a respondent in an application.
Respondent,
Why do you
yes.
want to-
Respondent submits that his client intends to resolve the dispute as was submitted earlier. Since the administrator is unable to attend the court, list this matter after 2 weeks. 2 weeks পরে আসবে। আচ্ছা, Mr. Gupta is directed to remain present, administrator directed to remain present on the adjourned date. Give a further notice to him.
I will inform him. Great.
My lord, a date may be fixed for after 2
দিয়ে দিন date একটা 18th.
18th, my lord. I'm deeply obliged.
এই তো কি?
Can it be fixed on 19th, my lord?
Call Mr.
18th I
Chaudhary.
have-
Call Mr. Chaudhary.
Mr. Das is.
19th, ask him.
I'll do.
19th
leaving
দেখেন?
to your honor.
Okay. 19th.
Grateful, your lordship.
I'm grateful to you. Right.
Sir,
দিয়েছেন তো আইটেম মাঝে গেছে ও রেখে দেবে 42 দেখ দেখি থাকে লিস্টে রেখে দেবো
this matter on 19th of
কোনটা
last
লাস্ট রিলিজ মারো
কেউ কি আছে ও ভেবেছিস কি আজকে অ্যাডজন্ট হবে ঠিক আছে Yes.
We have been taught by our senior that my lords may not be capable.
Item number 75, my lord. My other side was here. Now, there is only one difficulty, my lord. They have asked for, my lord, if lordship sees their back, but they haven't judged সাহেবকে।
কি করে মান্থলি লিস্টের লিস্টই আসছে না
Oh,
Monday
only thing, my lord, what I am praying, they have prayed for acceptance of the report of the Commissioner of Partition in a partition suit without annexing the report. So in that view of the matter, my lord, we being the defendant, we took the point of maintainability and then we said the report at least has to be annexed because this honorable court has to see the report. Only then it can be accepted and if at all decree then can be passed. So, my lord, there was a direction given by this honorable court for filing the affidavits. Now, my lord, there was some delay, my lord, 2-3 days delay. We sought to serve them, but they did not accept it.
So only thing what I am praying, my lord, since my learned junior, my advocate on record is carrying, if this can be, my lord, accepted, my lord, by this honorable court, and the time for filing the reply may be extended any day according to the convenience of the court. That is the only prayer.
Okay. এটাকে দেখুন যে নেক্সট মানডেতে যদি ডাকা হয় the other side ছাড়া তো হবে না এটা।
But they will still release to Tuesday. At least
আচ্ছা আবার লিস্ট থেকে বার করতে হবে। হুম opposition direction was given.
Yes, yes, that direction was given, my lord. Lordship can take it from me, my lord. But this matter may be directed to appear in the monthly list of January or any day when it is convenient. Only, my lord, the opposition
তাহলে
may
একটা
be
বার
accepted.
করে নিয়ে ওটা জানুয়ারিতে পাস করুন। টু বি মেনশনড দিয়ে দিচ্ছি টিউসডে টু বি মেনশনড তাহলে লিখে দিন give a notice to the other side.
Yes, yes, my lord, I would give, my lord. Thereafter, Lordship can pass appropriate direction for extending the time.
চলো
I am grateful, my lord.